All right. Good morning, everyone, and welcome to the Committee on Professional Responsibility and Conduct. And as a reminder, this meeting is being recorded. So Angela, can you take the roll?
Yes, Emil Ali,
Present.
Elizabeth Bradley, Raquel Brown,
Present.
Ravella Coleman,
Present.
Cassidy Shivers,
Here.
Mary Grace Guzman, Brandon Krieger,
Here.
Eleanor Mercado,
Here.
William Munoz, Daniel O'Reilly,
Here.
Akita Poindexter, Topeka Ravi,
Here.
and Carrie Riley.
Here.
Thank you.
Just real quick, for those of you on Zoom, can you hear us okay?
I can hear you just fine.
Okay, great.
It's the other room. Or is it just the two?
Could be.
It is muted.
Okay.
I think it's fine.
It'll
It's
be
not
fine.
too bad.
Okay,
Fine.
okay. Oh, you need the volume.
Yeah.
We'll just leave it right there next.
While she's doing that, I'm going to run to the restroom. Is that okay? Can I run to the restroom?
No, we have to do.
We're
public
live.
comment.
Oh,
Yeah.
sorry. Okay, I'm not gonna. Sorry. Oh, wait.
I have to too.
I know, I should have gone before, whatever.
Want to go ahead?
I got it. Okay, for the public comment for those participating by Zoom, please use the raise hand function at this time if you'd like to give a public comment. For those that are participating by phone, you can hit *9. That is the star key and number 9 to make a public comment. We are going to allow 3 minutes for each speaker. You'll get a 30-second warning, and after your time is up, your comment will be done. So at this time, if you'd like to give a public comment, please raise your hand and I will call on you. All right, so the first person I have is Phil Anderson. Phil, you may start when you're ready.
Yes, good morning, board. Are you able to hear me well?
Yes.
Okay, thank you very much. Yes, hi. I am calling today because there is some very pressing concerns I have regarding the behavior and professional conduct of several attorneys that I believe, at the very least, merit an investigation into the validity of their bar license, particularly for Kendrick Moxon and Robert Mangle and City Attorney Heidi Soto. I'll give you examples of what I'm talking about. So Robert Mangle, in about a week and a half ago, was at a court case regarding issues of sexual assault on a Scientologist. After the public hearing, Robert Mangle literally went up to one of the defendants and shoved her and outright assaulted her on the court hallway in the elevator, outright committing assault while serving as counsel. That's absolutely disgusting. And Robert Mangle is a Scientology lawyer. Number two, Kendrick Moxon is a name that you might have heard already from your fellow peers, but Kendrick Moxon has outright committed perjury in several cases. You can look at William Good v. Francois Koster, Scott Hochstetter v. Jaden Wheeler. There's dozens of cases out there where Scientology protesters have literally gone face-to-face with Kendrick Moxon, who continues to commit perjury. Number three, Heidi Soto has explicitly chosen not to file any sort of charges against two Scientologists who have committed absolutely heinous and despicable acts of sexually harassing and stalking minor children in broad public daylight. And the LAPD was even present and also chose not to file criminal charges against people who were adults exposing their genitals to minor children in broad daylight, as well as issuing threats of rape and even making swatting calls on their private residence. These children have had guns pointed at their heads, and two Scientologists are responsible for it. We know their names, we know where they live, we've already given this information to LAPD, and Heidi clearly does not care to prosecute child sex predators. And at the very least, she deserves to be investigated. Your children are up. Nobody's children are safe. As long as Heidi Soto continues to remain the city attorney, she literally is protecting chomos and child sex predators. And we have video evidence in several court cases to show for it. I hope you do your job because the world is watching. Thank you for your time.
Thank you.
Phil.
Are there any other public comments?
Yes, we have one more public comment from Maria Grijalva. Maria, when you're ready, you can give your comment and you're on, thank you.
Thank you. Good morning. My name is Maria Grijalva or Maria Grijalva in Spanish. I'm from the Latino Information and Resource Center, a social justice advocacy organization based in West Sacramento. I'm grateful to Phil Anderson for his comments. It's very telling, and yes, the world is watching. I'm here to enter into public record very important facts. Also, this information is available online. I was falsely arrested by the Yolo County District Attorney Jeff Reisig after I made a major contribution to his political opponent. I gave over $40,000 to a public defender that was running for office. It seems I was arrested for pressing the donate button. There is a serious conflict of interest when a licensee uses his bar card to arrest their political opponent. I filed a complaint with this agency, but it appears that there is a patriarchal culture at the bar that justifies this misconduct and the misconduct of a lot of other licensees. This is especially concerning because of the comments made by our bar chair. Chair Stallings has provided new moral turpitude criteria to the Board of Trustees. He indicated this at a previous meeting. He wants applicants with a history of participating at demonstrations, at protests, from admission to the bar. Such comments are racist in nature and reflect a patriarchal culture within the bar, a culture that harms the public, licensees, and women that work at the bar. Let's not forget, it wasn't until the 1960s that Black women won the right to vote. So anyway, a racial discrimination complaint has been filed with the FBI, but most importantly with the Department of Justice, alleging RICO and collusion charges by the state bar with licensees such as Jeff Reisig and the Girardis and other licensees that need to stop their misconduct. Thank you so much for this opportunity to speak.
Thank you.
Thank you, Maria. Are there any other public comments? Please use the raise hand function. I don't see any other public comments.
Thanks, Angela. So now we're going to go on to the approval of the minutes from the last meeting.
Okay, I'll take the roll to approve the September 13 minutes. Ali.
Wait, sorry, we need a motion.
Oh, yes.
Are there, may I have a motion?
I'll move to approve the minute.
Second.
Okay, taking the roll.
Please take roll.
Emil Ali.
I'll abstain as I was not on the first time.
Okay, Brown.
Present.
Bradley. Coleman.
Abstain.
Guzman. Mercado.
Yes.
Munoz. O'Reilly.
Yes.
Poindexter.
Yes.
Ravi.
I'll abstain.
Abstain. Riley.
Abstain.
And Chivers.
Approved.
Okay. We have 5 approved and 0 not approved, so that motion will carry.
Angela, do you see the other member who's joined virtually?
Yes, I do. Thank you.
Okay. Thanks, Angela. And now my chair report. So first, let's introduce the new officers. Hello, I'm Cassidy Chivers. I am the new chair of COPRAC. And we have Dan O'Reilly, who is now the new vice chair.
Hello.
And Brandon Kruger is now our new advisor. He is the past chair and he's going to continue to advise the committee. And let's introduce our new members. We have, I'm going to have you guys say a little bit about yourselves, if you don't mind. So let's start with Emil Ali.
Good morning, everyone. My name is Emil Ali. I'm a partner at a small firm, McCabe & Ali LLP. And I'm a registered patent attorney that focuses my practice on the intersection of IP and legal ethics.
Thanks, Emil. Okay, Novella Coleman.
Hi, I'm Novella. I work at the California Civil Rights Department where I'm a public prosecutor, but on the civil side. And before that, I worked at a bunch of legal nonprofits.
Thanks, Novella. And now Carrie.
Good morning. My
Riley.
name's Carrie Riley. I am the Global Head of Conflicts at Quinn Emanuel. Prior to that, I led the Business Acceptance Department at another international law firm and also worked as a state bar prosecutor.
Thanks, Carrie. And now we're gonna do the staff report, which Erica is gonna handle.
Well, good morning, everybody. Good to see everyone, and good to see everyone, or many of us in person. These are always interesting meetings because it's kind of dealing with a little bit of the behind the scenes logistics, but thanks everyone for joining, and thank you to everyone who's on Zoom. If Deepika and Vakita and Dan, if for any reason you can't hear us or see who's talking, I know it's kind of challenging in this room to see who's talking. Just let us know, and we can, in the past, we've said who's speaking before we speak, and we can certainly do that as needed. So thank you for kind of handling it in this format. Just a few really brief announcements. One of our committee members, Elizabeth Bradley, sad for us, good for her, was recently appointed to LA Superior Court. So my understanding is that she will be sworn in later this month. So she will no longer, unfortunately for us, I believe my understanding is that she will no longer be participating with COPRAC. So we do have an alternate member who was approved by the Board of Trustees, who we will be reaching out to and confirming that they are still interested in joining the committee. And then they will likely be appointed for our next meeting on December 6th. And then a few other just real brief things. So for those of you who are still following it, we are still waiting for the California Supreme Court to act on the proposed changes to the rules of professional conduct regarding civility. That has not happened yet. We will see what action they do take on that. And then two brief legislative items. So the State Bar's fee bill, which is AB 3279, was approved, which will go into effect January 1st, like most bills do. There are some changes to the State Bar as it relates to that, mostly administrative, but just wanted to make you aware of that. One of the biggest changes that I'll just note that does affect professional responsibility is there's a new confidentiality exception that was added to the rules. So there, within it, it does allow for, related to the Client Trust Account Protection Program, it allows for lawyers to share certain client information as it relates to compliance reviews and investigatory audits that are conducted, so that, typically fee agreements, billing information is typically privileged and confidential in many instances, and it allows for that to be shared with the State Bar for the limited purpose of those investigative audits and reviews, but the statute explicitly says that the confidentiality and privilege are maintained despite sharing it with the State Bar. So there are many other changes in that bill, but that's the big one to share. And then there's another bill that's, a few others, but another one that's relevant to this group to some extent is SB 940, which is going to it requires the State Bar to create a certification process for alternative dispute resolution providers and individuals. It's an optional certification process. So an ADR practitioner, firm, or provider may, but is not required to become certified by the State Bar. So if you, because you're affiliated with COPRAC and you get questions about that, you can send them my way. And that will likely be implemented probably mid-year 2025 to open up that certification process. So happy to answer questions on either of those things or the fee bill more generally, but that concludes my staff report otherwise.
Mr. Kell?
No questions on those two things, but
Yes.
a question and a request. Actually, two questions. And I don't know if one of them goes to Cassidy or to you, but the first one was we were asked about the new form 2201,
Yes.
which is
as far as I got.
Yes.
was to indicate relationship attorneys and their license. What is the purpose of that, and who has access to the information?
Great question. So Rule 2201 is an internal rule to the state bar. And what that basically does is those who are too close to the state bar, essentially, and a complaint is filed against them as an attorney, that's referred out to individuals who are not employed by the State Bar of California. So they're referred out to independent prosecutors that are contracted with the State Bar, but do not work for the State Bar. So for example, if there was a complaint filed against me as an attorney, our Office of Chief Trial Counsel would not handle that complaint. It would be referred externally. So similarly, for committee members, if a complaint is filed against a committee member, as a public member, Raquel, it wouldn't apply to you because there wouldn't be a complaint filed against you in your attorney capacity. But that's the purpose. So it's to determine if there's anyone who has a close relationship as a committee member where they would need to evaluate whether that complaint needs to be referred out to a third party. So for example, I have family members who are attorneys. They're on my 2201 list because the Office of Chief Trial Counsel needs to determine whether or not that complaint, if there's one filed against them, needs to be referred out.
Okay. The second question is related to Phil. I wasn't quite sure. Maria seemed to tie what she was saying to Phil, but it seemed like she had a different
Sure.
issue. Is that not just, he could, like, has he done something? He seems to say he's made some kind of action with the state bar.
Yes. So my understanding of this, so there, I believe Mr. Anderson has made comments at other state bar meetings as well, including at the Board of Trustees. There are allegations made against attorneys as part of the complaint. Those would be complaints that would be filed with the Office of Chief Trial Counsel, and then they would take action on those individual complaints. That's not something that COPRAC does.
No, I understand that. I'm just trying to understand, is he just going to meetings, or is he actually like 8.3, right? If you see an attorney that's doing something, there's a rubric for him to do it. So I'm just trying to understand
what his motivation is.
Not what his motivation is. Is he taking action? Has he taken an action that will get some result versus just coming to the meeting and saying something and we say, okay, duly noted, and go to the next agenda item?
Yes, I believe he has filed complaints against this, but I can certainly follow up and send an email confirming that.
All right. Maria, like I said, seemed less so. She was
on
a different.
Based on her public comment, it sounds like she had filed a complaint.
Right.
And then there's a process. So if the complaint is, just for what it's worth, if the complaint's denied by or not moved forward by our Office of Chief Trial Counsel, there is a review process for that a complaining witness can avail themselves to.
Okay.
Yes.
I had a related question. When people file complaints or make comments with things that aren't within our topic area or jurisdiction, do we refer them to the public entities that handle those things, or do we just do what we can that's within our jurisdiction, and then they find or don't find who they actually need to report it to?
Typically, frankly, we don't typically get very much public comment. This doesn't happen that often, but when it does, we either have, they have already commented at many other meetings that are more relevant to their comment, and they've already been reached out to, or yes, certainly we can, and we have done so in the past to direct them to the right place.
And the other thing, which is somewhere but seated between the chair and staff, so I just want to say it publicly to go on record, is I've made the request that it come on an agenda item regarding the duties and responsibilities of vice chair and chair in the process, so that those that are interested have the opportunity to know what is required, what's the timing, et cetera, and perhaps have those who have served share what their experience is, beyond just what is written in the document. So Eric and I have had that conversation, but I would like it to be agendized, if we will, sooner than later. I think it's at the beginning of each fiscal year or calendar year. Is that right? And the process begins?
Yes, correct. It starts.
So perhaps at our next meeting, we could have that on the agenda.
It's okay by me. I can tell you about my experience from the last 30 minutes, but.
No, but you were vice chair, right?
Oh, that's true.
Yeah,
I was vice
so-
chair. You're right.
So you,
Yeah, no, that's a good idea.
thank you. And nothing further.
Okay, anything else? Any other questions? No. Okay, so let's go to business. So we're going to talk about item 4.3, draft opinion 20-003, flat fees. I think this is an item for approval, and Erica, you're going to take.
Yes, thank you, Cassidy. So for just to kind of catch everyone up, so this is an opinion that Joel Mark was the primary drafter of, and he his term ended at the September meeting. So if you'll recall from the September meeting, he did very kindly offer to make his additional revisions and send them to us. We invited him to join us, but he decided that he felt that he didn't need to participate in going through the opinion. So what's on everyone's screen and what you can see in the room on the screen is those revisions. The red line is just a crossing out of the comments, frankly, that I had made in the last round. So you had seen those red line changes. Joel has more or less accepted all of those. And so there's just a few minor things that are left in red line to kind of talk through. I will point out a few of them here. The biggest one is on line 165 of the red line. So Angela, if you don't mind, thank you. Right. Yeah. So 165 and 166. This is a new addition. What the opinion said previously was something along the lines of the committee believed that the disclosure of the fact that flat fee funds held in a lawyer's operating account were subject to seizure, essentially, because one of the benefits of maintaining funds in a client trust account is that those funds belong to the client and they cannot be seized as the lawyer's assets. And so it said that the duty to disclose the risk associated with this was part of Rule 1.15B. It doesn't really say much different, except that it's now referencing the communication rule 1.4 as opposed to 1.15. So just wanted to point that out to the committee. We can certainly talk about that. Let me go through very quickly, though, the other two things, and then we can move back up. On line 186, I don't know how closely you all have looked at this. I think this is another change that we maybe need to tweak the language in just a little bit here. The sentence seems a bit off. I think we're just missing a couple words. But basically what it used to say, as you can see on the screen, is that, anything related to the flat fee cannot be unconscionable. And then it clarified that part of an unconscionability analysis is that it needs to be proportionate to the reasonable value of the lawyer's services and so forth. So Joel added a little bit more language there to kind of flesh that out. But we can stay there for a moment so people can read it, but it seems to be missing something.
Can you scroll down just a tiny bit so I can? No, up, sorry.
What came before?
Yeah, okay, any such provision must not be unconscionable, including an analysis of whether, yeah, that seems like it's like a non sequitur.
Right.
Maybe we need a period after 1.5 and then start the next concept.
And then, yeah, and
then a lawyer, I think, should analyze whether the contract assigns a
Value.
value that is like disproportionate. That's kind of what
a lawyer should or must.
It's either that or to determine unconscionability.
Or should I like.
I would swap otherwise and would. Read or would otherwise result instead of.
Is there a way for you to zoom out a little bit just to make so they can see more of the, or just do a paragraph break to move it down so we can see it together, starting with however.
Do we need to add a comma after tasks?
Go up to where however is and just hit enter a bunch of times.
Could you repeat what you said, Topeka?
Do we need to add a comma after tasks? to break up that clause?
It's not proportionate.
I think the
Wait.
other task right before that.
I think that's right. That's a list, but it's hard to read without commas in it. Those are three different things, right?
Yeah.
Well, and this is not an exhaustive list. And so I think that further on in the opinion, it does have a bit more that talks about that list or like what those unconscionability factors, right? 1.15 has, I believe, 12 factors to be considered as it relates to unconscionability. And this is not that.
The lawyer sentence is still off. There's something that doesn't make sense there. Whether the contract assigns values to any particular task or tasks is not proportionate to the reasonable value of the lawyer's services.
That are not proportionate, or assigns values to any particular task or task that are not proportionate to the reasonable.
Right, that's good.
I don't know if it should be that or which. I've always been unclear.
That. If you're gonna have a comma, you use which.
Yeah, exactly.
But I don't, do we need the comma before or after task? Shouldn't it be task or tasks?
Yes.
I think you can take
That
comma
sounds
out.
right.
So task or tasks, and then I think which are, it would be which are not proportionate, right?
For the contract signed for
If
any
you
particular
have a
task.
comma, yeah.
I mean, do we really need or tasks at all?
Can we do like a parenthesis?
Yeah, just any particular task
Yeah, like take
Right.
out or
that
task.
is not proportionate.
Task.
That are not.
Mhm.
Any, that is.
That is.
Value, oh wait, values is what we're talking
That is
about.
not proportionate.
So it's R, wait,
Yeah.
assigns value,
We'll just change it to.
Oh my God.
value.
Should be value. Yeah.
assigns a value.
Isn't this what you wanted to?
I know, and that's, I'm like, let's get into it, guys. One sentence, we're gonna spend a half hour on. Assigns a value, assigns a value to any particular class that is not proportionate to the reasonable.
We can put a comma there if we wanted to.
Yeah.
Yeah, I would put a comment after that or, yeah.
Or would otherwise.
I
think-
don't understand that. How would a refund make?
Or
The,
what-
I think it's talking about a very small refund,
Correct.
but I think the way it reads, it's confusing because like, what if I refund too much? It could be unconscionable.
right. That's what I don't understand.
Yeah, that doesn't make sense. Or would otherwise result in a disproportionate refund? I mean,
I
But
don't
how
think
is the refund making it unconscionable? It's lowering.
if it's too,
If
if
it's
it's
too
too small, if you're like, but it's
Ah.
just,
If it's too small.
yeah, but I mean,
I think it would be
Won't
or
be
the
too
amount, or the amount
Lawyer side.
refunded to the client would render the fee earned
Yeah.
unconscionable.
yeah,
Might I suggest we don't need to talk about the refund?
right, I mean, I was
It sounds
thinking
like
that
a
too,
cross.
yeah. I mean, it doesn't really
What,
matter.
say what you said,
We
Brandon?
might not need to talk about a refund if
Yeah.
the real operative thing is that the contract is not citing an unconscionable fee for each task.
So
That sort of,
might I suggest we just go back to the original language in the sentence?
Which was?
shouldn't we do that in like an hour?
Hey, advisors.
However-
Stay
however,
stay
any
above the
such
table.
provision- Any such
Why
provision.
not just remove the or would otherwise to unconscionable?
Decision.
It lures you down the web.
What do we talk, so any such provision, if you miss something,
I would delete that refund clause. I think that would probably be sufficient, but you could also go back to the original language, which would work as well.
Yeah.
What was the original language?
It's basically on screen. So however, any such provision in a fee agreement must not be unconscionable under Rule 1.15, comma, should be proportionate to the reasonable value of the lawyer's services, comma, and should not adversely impact.
And so what was the thinking of making that more explicit? Do you know from Joel?
I don't.
But there was some intention.
It was very, yeah, I mean, exactly. So Angela, if you don't mind, on line 190, if you want to just really delete the or would otherwise clause.
Oh,
Through unconscionable on 192. Thank you.
so now it would be not part of the sentence, correct? Line 190?
I
You
think-
should analyze whether the contract assigns a value to any particular task that, is not proportionate. Okay.
I think and whether the contract adversely impacts the client's right to terminate the attorney.
Just don't cheat the client. How about we say that? Just don't cheat the
Well,
client.
where we go through the unconscionability factors, if we go through them already, then are down below.
That's not so
Love the whole opinion.
the final clause is not part of an unconscionability analysis in 1.5. So that's the reason to have that additional language is there.
So besides that, maybe we could hear
So-
some of the other things you have, or is this the last one?
I have one more thing, but for one, just real quick. So basically there's two things at issue here, right? There's the unconscionability analysis under Rule 1.5. To attempt right, but that's part of the unconscionability analysis under 1.5 anyways.
Right.
So I'm not sure why we're calling out just that single factor.
Right.
So what you could do is you could just have, however, any such provision in a fee agreement must not be unconscionable under Rule 1.5 and should not adversely impact the client's right to terminate their attorney.
Yeah, instead of trying to rephrase briefly what the 1.5 now.
And we do, the opinion, I believe, further down does talk about the reasonable fee analysis.
I like the shorter version. I like that.
Okay. So,
Do you want me to delete all that?
yeah, so starting at right after 1.5, you can delete everything up to the and. And I don't think we'll need a comma with that because I think it's short enough. Great.
Oh, there.
Okay. And then moving on one other area, so two things here. So we're going to line 277, or what was line 277. We may have tweaked it. Go scroll up. Sorry. Okay, so there's a comment. So we're now actually at line 273. So this was just a flag. So starting at line 273, can you scroll down a little bit so they can see the paragraph? There's a reference to arbitration advisory 1998-03. That arbitration advisory is currently being redrafted. That's 2022-OXB. That's also on our agenda today. So just flagging this to the extent there's basically two options here. If the committee thinks this opinion is ready, which staff does, it could be voted out today. Alternatively, that 2022-OXB opinion will likely be ready to be voted out at the December meeting, depending on what the committee decides to do today. And so as it relates to kind of the process here, the next meeting that these opinions would be approved at will be by the Board of Trustees would be after that December 6th meeting. So these would go together essentially to the Board of Trustees. So if the committee does decide to vote this out, committee could vote this out today and ask staff to update that. Or the committee could keep this opinion until December and then adopt this as well as 2022-OXB at that next December meeting.
I mean, if it's ready to be voted out, we can vote it out, but and I think we should do so. but it doesn't really make a difference, really.
It frankly does not make a difference. No, the Board of Trustees meets next, November, I believe it's 14th, 15th. I'm not quite sure the Thursday, Friday, or 15th, 16th. And so it would be after that meeting that these items would go.
Because it's too late for that meeting, right? It's too
Yes,
late.
14th, 15th. We have someone in the audience who reminded me of the dates. Thank you.
Well, we can vote it out. If everybody wants to vote, I mean, if we're ready to vote it out, we think that it's ready to be voted out, then I think we should just go ahead and vote it out and get that, crossed off our list of things to do, basically. Does everybody agree? Yeah? Okay. So are we still presenting or are we voting?
No, that was it. So everything else, in the opinion, again, at the September meeting was largely incorporated and discussed as it related to the public comments that we received on this opinion. Those were just two minor additions that Joel added as the lead drafter to the opinion. So long as everyone is comfortable with the revised language that we just did, and then the clarification that I do think we should maybe go back to line 165 and talk a little bit about the advising that communication is required under 1.4.
Do you want me to reprint?
Yeah, do you mind bringing that back up? Thank you.
165.
So that's a somewhat controversial point, right?
I think so.
Because it obviously makes sense that if this is attachable, it seems like a material issue that you should tell your client, but the rule itself does not state that you must spell out that impact of allowing you to keep it in trust. So the issue is, are we, going farther than the rule or just reasonably interpreting it?
Correct. So what I'll just say to this, so it used to say that it was required under 1.15B.
Right.
And so under 1.15B, there are disclosure requirements to deposit a flat fee over $1,000 into a lawyer's operating account. And this opinion basically said that you need to explain the consequence of doing so pursuant to your 1.15B obligations.
But wouldn't they have codified it? I mean, they just updated this rule a few years ago. Like, wouldn't they have codified that disclosure in the other disclosures if they felt it was important to tell the client, like, by the way, this could be seized as one of the risks of waiving the right to have it held in the IOLTA versus your operating account?
Yeah, and it's not informed. I mean, there's an informed consent is a deliberate, term that's put into the rules, and 1.15 doesn't have that in there. And so why, that explanation, I mean, I think we're going beyond the rule. That explanation is not
We're
required.
definitely going to be on the rule. And maybe it's a really good normative outcome, and maybe we should actually address ourselves to the rule.
Right.
If we think it's a good idea. I can't imagine why any client fully informed would say, yes, please put it in the more risky account.
So, Raquel, you may just want to look at the sentence right before it, because it did just recommend that this is.
Right, it's just right.
It says that this possibly, I think it needs to say possibility, actually, now that we're looking at it.
Yeah.
The committee recommends that this possibility, line 164, is conveyed to the client. And then that new sentence just does take it
A little step further.
a bit further. And I'll just, since I did work on incorporating public comment into the opinion this September, that was a request by public comment to go that step farther and say that the committee believes that such disclosure is required, but the public commenter suggested that it be pursuant based under 1.15B, not 1.4. So Joel moved it to the communication rule as opposed to the client trust accounting rule.
Can we change it to disclosure is prudent or something? Because if the
best practice.
Yeah, because it's certainly not required under the rule at all, but it definitely, if the client's gonna come and complain that I didn't have informed, when I waived my right to have it deposited in the IOLTA, I didn't know what I was waiving. like, it's a good safeguard for the attorney to say, well, we talked about the risks of putting it in the operating account.
Yeah, but are we gonna go so far as to say that the lawyer is gonna be disciplined because they didn't, have that full explanation? You're saying, no, they shouldn't be disciplined.
Isn't the lawyer gonna be disciplined when the client funds held in their general account are seized by creditors?
Well, that's.
Not if the client has.
Not if the client knows.
That would be a civil issue, not
Are we all
a
okay with that?
disciplinary issue.
Well, I mean, I agree.
I don't
I'm
know.
not saying it needs to be addressed in this opinion, but maybe this is an issue that we should be looking at.
But the impetus behind this rule is about protecting the public from attorney misconduct, not from creditors seizing bank accounts.
I understand, but I guess sorry, Raquel's raising her hand. I haven't done that yet,
Yeah,
so
raise my
be
hand.
quiet.
Everybody's just jumping right in. So,
Yeah, go ahead.
I do think there's issues with 1.15B from the top, right? And so since y'all so it's one of the things I noted, and somehow I woke up to it as I was reading this one more time. I think we've synthesized it enough that some of the things struck me. And I think you're setting, first of all, we're talking about small clients. We're not talking about big firms. And so I think that is the difference, this idea that, oh, the client will know and, they're sophisticated. They're not. That's why we have this. So I think that, and I think we're setting up an inherent conflict risk by saying to attorneys, you can take money and operate with it, which you have not earned and are subject to you giving them back. So I think just that idea that we're saying in 1.15B that it's okay to do that, because that's where the complication comes in, because they don't want to give the money and they're going to do everything they can do to try to figure out that paragraph sentence we were talking about, how it's not unconscionable. Not because it's not unconscionable, but because that money has long been allocated and used for something else. And so we're using something, so it doesn't directly relate to this, but I do think it's something that should be revisited if it's something we have purview to do, because I do think,
To eliminate 1.15B, essentially.
yeah, not to eliminate it, but to really, but to make, I think often a lot of our logic is coming from the protection. We say it's for the client, but it's really about the commentary is about the attorney. And I just think that I'm a public member and I'm looking at both sides. And what I hear more often is on the other side. And most of these things come with less sophisticated clients. That's why they're on our table. The big guys know that, we don't have to say anything to them about this. They understand how to keep and get their money. They just know how to do that. So that's sort of like says tangential, but we've introduced it because now we're tying something that is really important. And obviously clients want to use their money as soon as they can. But the reality is that it's not earned until it's earned. So that was something that struck me as I read through this opinion as we're about to finalize it. I think it's inherent, sets up a conflict from the original signing of a contract between a small client and an attorney of any size who is going to be more sophisticated than that client.
So you think there should be heightened disclosures, more informed disclosures beyond what 1.15B says?
Well, yes, but I also think even deeper, like if you haven't earned it, you shouldn't be operating with it. Because that then sets up the conflict of why you don't want to give the money back, which is the relationship is because we tied it to a rule that says you can do it.
Right.
And so I'm talking about revisiting the rule separately from this.
Oh.
Separately from
But
this.
we can't do that.
The flip side of this also is that it's also for advanced fees and costs. So the flip side is you have a client who's not so good at paying their bills, you file something or you request a transcript that costs $3,000. You're not allowed to get an advanced payment for fees and costs from your clients. And then the client stiffs you, and the small attorney who hung a shingle is not able to recover that money unless you're requiring them to put it into a trust account. But then they can't take it out of the trust account until they've spent $3,000. So it's like, it does go both ways here. There are reasons to have funds that can be deposited into an operating account before you've spent them, which is exactly what we're talking about here, like ordering transcripts that are expensive.
But that's the cost of, I'm a consultant, a management consultant. So that's the cost of doing business.
But
So
then
when you hang your
you're gonna
shingle,
show-
you have to have
But
operating
you're going to
cash.
show representation of indigent clients if you tell attorneys that there's no way for them.
I'm not fearful of that.
I very
You should be, yeah.
You
No,
should be.
What I'm
That's a very,
saying
very
is, if you hang a
serious-
shingle, you should be able to operate the services that you say you can provide.
Well-
And if you're trying to rob Peter to pay Paul to represent clients, it's
No,
only a matter of time when you
That's
won't.
not what I'm saying. That's not what I'm saying.
But I'm,
Well, I understand that's not what you're saying, but that's the mindset, because you're saying it's a shingle and he needs this money to do this service. And what I'm saying to you, as somebody who understands flat fee agreements quite well, is that you're not really set up to have a business, because a business means you can cover these things until you get paid. That's.
I think we should distinguish fees and expenses.
Right.
Yeah.
That is also
Costs.
different costs.
so, and my
Right.
question is, like an honest, good faith question, because I just do all this through my trust account. I'm not really seeing the difference. If there are deposition transcripts to be purchased, if the client has the money, I don't see how it increases access to justice for me to put that in my operating account. What is that? My trust account. That's not how I've ever seen this. And I know this is directed at the rule. So, I mean, what I have, I guess, is a criticism of the rule, which I don't think needs to be hashed out here, but maybe does rise to the level of something we should talk about.
like a comment? I mean, so wait, how,
Oh, not in the opinion.
No.
Not in this.
I think it's like a totally different, like, hey.
so we're gonna propose a revision to rule 1.15?
Not in.
No, I'm
here.
suggesting it doesn't belong in this opinion at all.
Oh,
Yeah.
1.15 doesn't belong,
My
Our-
criticism.
our criticism of it, okay.
But I do think maybe it's something that the committee should be looking at. If we,
A revision of the rule?
yeah,
Yes.
or critique.
So I think
Oh, okay.
we're hearing I think we're hearing that there are flaws in 1.15B, client protective flaws in 1.15B, which may be that they need to disclose the potential adverse consequences of placing funds into an operating account that the lawyer or the law firm's creditors can attach to those funds. I think we're hearing that there's maybe never a good reason to put those funds in the operating account, regardless of whether or not the client is informed of those possible adverse consequences, which would be either any of these things would be a change to 1.15B, either in the body of the rule or a comment. And then there's just this opinion and what we should say in it.
Correct.
Because there's a whole, like a can of worms being opened here about 1.15, and you gotta assume that whoever drafted it, and I can't remember if we even participated. in
This was part of the Rules Revision Commission work.
Right, thought about this stuff, you know? I mean, what about unearned fees and the fact that there couldn't be a refund and, you know, all of that? I mean, of course they thought about this, and then they chose not to put that. I mean, I'm not saying, but like, it's a pretty.
A lot of credit to some.
Emil, go
They
ahead.
thought about it, they just didn't have us.
Right, go ahead, Emil, sorry.
Sorry, Novella, did you get to?
Oh, I was just gonna say I take folks' criticism about 1.15B, but for the sentence after that, because the disclosure and informed consent is so fact specific and about like what type of client it is and what type of matter it is, I wondered if that second sentence could be more like acknowledge more that like depending on the client and the circumstances, disclosure of that possibility may be required. Because I think when I was thinking of the clients I've worked with, like I could see them having like no clue that that's what that means. But then as Carrie was talking, I was like, okay, maybe there are clients who understand
that ramification. And so maybe it's too harsh to like potentially discipline an attorney if their client is the type that actually understood the risk and wanted to do it anyways.
So there's an opinion that just came out a couple months ago in July that talks about flat fees that Joel talked about at the September meeting. That's the Dixon opinion.
An ethics opinion?
Sorry, a case law, a court of appeal opinion.
Okay.
And what that opinion involved was a $565,000 flat fee that was properly put into an operating account with the 1.15B disclosures. But the court determined that the firm did no work in the case to earn any of those, any of the funds. So there's the advance fee analysis and the true retainer analysis in that opinion. So I don't want to get distracted by that in the sense that I don't think that opinion needs to be cited in the ethics opinion, but there are a range here of clients that have, I mean, a $565,000 flat fee is very different than a $1,500 flat fee for which 1.15B disclosure would be required.
So wait, what happened in that case? So they just deposited a flat fee into their operating account and didn't comply with it.
They did comply. It was about the reasonable value of services and how much of the fee should be awarded to the firm. And the court ultimately found none of it.
None of it.
Awarded to the firm.
And it was required to be refunded.
Correct. And there was no creditor issue, like the money existed. So there's no creditor issues here, which is, that's kind of the point in this analysis, in this paragraph at least.
So, and sorry to rehash it. I mean, I think there's a great conversation on maybe, I don't think there's two sides. I think there's multiple sides here. So I guess the thought process that I go to is first, what is this? This is a guidance document mostly used by lawyers, but it could also be used by regulators. I don't think the public is necessarily going to look at this guidance document, but the public is going to benefit from how lawyers interpret these rules. And I think like half of the states allow you to put a unearned fee into an operating account. That's what we're talking about here.
Without disclosures.
No, with disclosures.
With disclosures.
The standard kind of 1.1, but
Yeah.
I don't know of any state that requires you to talk about the what if of a creditor. And that's the issue. Because imagine if lawyers who are very bad business people, like lawyers, doctors, professionals, are not good business people, right? That's why we have practice management solutions that help us do these things. That's why we have staff, all that. So you think of criminal defense attorney. That's where I see a lot of flat fees paid in advance. That criminal defense attorney sees somebody at the courthouse and they're like, I need you to come do this prelim with me. They do the prelim and it's like $1,000 flat fee paid in advance, and maybe it's cash, whatever, but put in an operating account, whatever it is. That lawyer could go spend that money right away. And that's the same thing as having a creditor attach it. So I don't think that we should change the rule necessarily, but that's a different story. I also don't think that we should create a new requirement based upon the idea that, our Supreme Court, as well as the Supreme Court of many other states, have basically said, yes, we probably know the risk of attachment. We know this risk of creditors. We know this risk that some people just spend money when they haven't. And
Some people.
yeah,
All people.
But we also see the other side, that we need these lawyers to be able to, efficiently help represent a lot of these people. So that $560,000 advance fee, that's not what we're really, that's not what I'm talking about, right?
Right.
What I'm talking about is the $1,000, $2,000, $3,000 flat fees. And, I think the rule is imperfect, but it strikes a good balance. And it kind of helps people, especially in multi-state practices, fit in with everyone else. Because if we change it to say you have to get informed consent specifically to the fear of creditor attachment, that just creates relation.
I agree. Thank you. I agree with you, because I'm looking at the rule that you say, you tell them they are entitled to a refund, and you tell them it's going into my operating account. Most clients should say, well, what if you spent the money, or what if it's you know what I mean? Like what, and so by creating that extra requirement, which is not in the rule, I think goes too far. But I'm grappling with, well, do we still make it a best practice in the opinion or make it a recommendation?
The sentence at 164 may do that currently.
Yeah, I know. But maybe
It's a question
it
if
should
you
be
if you want it
tempered with like
stronger
addressing,
than that.
well,
Yeah.
it should be, or not stronger. We like to the extent you're dealing with an unsophisticated client who doesn't understand what deposit in an operating account and a refund means. You know what I mean? I mean, I don't know if that just kind of
So what about?
it's not helpful.
Yeah, that's saying, depending on the level of sophistication of the
Yeah.
client,
It may be
it
recommended.
may be helpful to discuss, X, Y, Z.
And it could be, I mean, and so then we're talking about then it becomes a 1.4. Is it a significant development that you're dealing with a really unsophisticated client? You need to explain more,
So I am unhappy with 1.15, but I don't think we are gonna fix it in this opinion. I don't even think we should say you should do something that 1.15 doesn't require.
Yeah.
And I think we should.
Just eliminate this whole thing, this whole
Just
part.
this issue,
Yeah.
and I think 1.15 was changed after 1.4's general thing, which is longstanding. So it's more specific. It was a decision to allow this thing that I don't think really is beneficial. But that's a totally different issue and not helpful to this opinion. I think we should remove this issue from the opinion. And I say that as a person who's unhappy with things.
Okay. And also just from an enforcement perspective, this is not something that is ever.
Yeah.
Well, and it's not something that is ever part of when we are evaluating a complaint for a fee that wasn't returned, like whether or not we do look for was the disclosure signed, but we don't look at did the person understand the risks of what they signed, what they were agreeing to when they signed it. We just look at the four corners of the rule and see, did the attorney comply with it or not?
Raquel has her hand up and then I have.
Okay.
So I have a question of something that was introduced that I didn't see in there, I don't see it explicit, which was this idea of creditors. Did I miss that?
Scroll up. Yeah, thank you.
What line are we looking? What line should I be looking?
So it's the inherent risks section. I believe it may be even, I can't see the whole
It's
thing.
not in
You go
that
higher up.
paragraph, okay.
Scroll up. Yeah, it's there. So because the funds are spent or may have become unavailable. Starting at 149, but really it's lines 151 and 152.
Okay.
Funds are having it because of intentional.
Creditors.
I mean, it's just in the idea of have they spent it and they don't have the money to refund?
It's this, creditors, yes, but also just spent,
You're right, no,
going
I
on
just
vacation.
realized that was introduced and I'm like, okay.
Yeah.
It's
So
Like one little piece.
Yeah, okay. So, yeah, to Cassie, your query 10 minutes ago, my comments are not that I think we should change 1.15 and have some implication here. My sense is that this would go however it would go out, however we approve it. Now, if we later come back and say we want to look at 1.15, then we would say, okay, is it futuristic? Is there some, we know that we've connected it in whatever opinions we have connected, we would have to go back and look at them and see, is there anything that would require a change? That was how I was thinking of it, not that we should connect them. Well, and I do think this idea of putting the onus on the attorney to say the level of sophistication for a client seems
Nebulous.
ineffective. Let me just say that.
Yeah.
In other words, it's the assumption that you have all different levels.
Right.
And so in some way, make your rule to the lowest level. if in fact, one of the tendencies is to protect the public, then make it to the lowest level. Don't make it always to the higher level because you know that you're going to miss the lowest level.
Erica?
I keep seeing Dan go off mute, so I want,
Oh.
and then I'll laugh.
Sorry.
And then I'll chime in.
It's hard to run a
Yeah.
meeting when I just want to talk.
Yeah, no, I'm not shy. I won't have any problem about trying to break in, but I'm in favor of the formulation where we just take this out, partly because I don't know what 1.15B is really about, other than I expect that, to Emil's point, there were people who do a lot of high volume, low dollar transfers of stuff for certain things. Then they didn't want to constantly be transferring funds back and forth. And so, but it does exist. 1.15B does exist, and it doesn't require a specific disclosure. And I don't think that we should read into it something like this, because it would become a standard of informed consent, basically.
Right. I have a question though.
Yeah, yeah.
Well, along those lines, just, and I don't know the answer to it, but if you fully satisfy 1.15B with your disclosures, does that mean that there's no 1.4 is off the table? There's no, like, you don't have to go through a 1.4 analysis of it, whether or not the, broader question of, is there significant development that needs to be discussed with the client related to the deposit of a fee in a operating account?
So there's a few things here. There's what Carrie was describing as the discipline standard, right? That is the bare minimum that a lawyer has to do to avoid discipline.
Not that.
Typically, these opinions don't do that, although there have been conversations recently regarding these opinions about how they can create malpractice liability and other types of liability that are not discipline. If it says something, it's, it's essentially expert
Standard.
Yes, exactly. So I think that is something that the committee needs to determine what they want to do in this space. So as we've discussed, what starts this section of the opinion, which we almost just avoided about half an hour ago, does currently say that the committee recommends that a lawyer disclose the fact that the funds may no longer be available if they are deposited into the operating account, because the lawyer spends it to go on vacation, because the lawyer spends it to pay their rent, because the lawyer has a creditor, for any reason, essentially. So from a client protective standpoint, if the committee recommends this, it's possible that more lawyers will include it in their disclosures. It's also possible that failure to include this could become
A standard.
a civil issue.
Right. Or
Absent a Rule 1.15B change, it will never be a discipline issue.
Right.
Right, but I don't know. I'm hesitant. Like now I see experts out there saying, well, the general reasonable lawyer would have this disclosure based on this opinion.
Well, why wouldn't you want to have it as a reasonable lawyer?
Because your client will not say yes once you explain all.
But the rule only requires disclosure. Right.
Like, I'm gonna spend this money,
Really a reasonable lawyer.
Yeah, I don't know. I think we should take it all out. I think we
Raising a
should.
risk that doesn't exist. Some lawyers would view it that way, right?
Say
It's
what,
like,
Eleanor?
there is no risk I'm gonna spend money if it's refundable or that I wouldn't preserve
should have.
it, so.
Right,
Why am I
exactly.
disclosing this to you when there's no risk, so.
Yeah.
It's like raising concern that doesn't exist. Now, for some other lawyers, maybe there is a risk, but is that gonna stop it?
There is always a risk. If I give you money, you're gonna use it. Right.
There are a lot of other risks that aren't addressed, but I also think the rules text just
What
says,
did you say?
Sorry,
We
Dan.
can't hear you, Dan.
Yeah.
Wait.
Go ahead, Dan.
sorry, I was just saying, a lot of other rules or risks that can be associated with this, like you have an amount that's over the FDIC deposit amount, right? And so it's not insured anymore and the bank goes under, or
Right.
whatever. Your assistant embezzles it, who knows?
Right.
But the rule just requires disclosure. It doesn't even really require anything beyond that. So if you get the disclosure, you've complied.
Yeah, I mean,
I agree with that.
the disclosure is you're entitled to a refund. The assumption is that I'm gonna have that money for the refund. I'm gonna do my best, but there's gonna be, there's risks with everything, right?
Well,
And
there's risk with the trust account too.
Right.
for some-
Exactly.
For some lawyers.
Yeah, that's
Exactly.
right.
Well,
We've seen
yeah.
that. We've seen that
Yeah.
here.
Just one more thing to point out, if we remove this, it will need to go back out for public comment.
But we still have the time
Good.
to deal with it in conjunction with the advisory? No.
Yeah, I mean, yes. And the advisor doesn't have to, I mean, again, this is why these things take time.
But
So
this
can you
is good.
explain, like, if we remove just the sentence earlier, or which part, like?
So currently, the opinion as it went out for public comment said that this is something that should be disclosed. If we remove that from the opinion, it's a substantive change to the opinion to no longer say that this should be disclosed. We may get 0 public comments on that. We may get people that say you should put it back in. We may get people that say this is great. This shouldn't be there anyways. But where we are.
Okay. So I think we should remove it. I think it's an important point that we missed before, that we're deciding on now. And I think it's fine to put it out to public comment. So what are we removing though? What part? How much? Maybe like the whole.
Isn't it that red line?
No, so I mean, I think you would perhaps remove more than that.
So definitely 165, 166?
And in order to remove it, the committee has to vote on it, yes?
Yeah, right?
Or do we have to propose what is being approved?
Well, remove.
Sorry.
Okay, so since my understanding was this was here for the final vote today.
Yeah.
But if now we remove something, we have to take a vote that the committee agrees to remove it. We
Right.
can't just, a few people say, yeah, let's remove it.
Right, so we'll vote.
Is that correct?
Right?
So we would have to vote it out for public comment, correct? And we would probably do a straw poll. I think it
I
makes sense to do
understand. Right, okay.
a straw poll to get the sense of, it's hard to see the sense and the people on screen.
Right.
But as far as, I think you're looking at removing the entire section A. So if you can scroll up, Angela, to keep going. Oh, sorry, too far. I'm looking at, I believe, starting at line 149 on the one that was posted, but there you go. So 130. Go back up.
Go back.
130.
I want to read the heading.
Disclosure
of
of risk, yeah. Oh, we should go.
I mean, okay.
So the first paragraph's fine.
So can I just ask a question, just so I can follow the conversation? Are you saying that you are talking about removing this portion from 130 on?
I think what we're discussing is how much needs to be deleted to not require a disclosure of the risk of putting it into the operating account. So the rule requires that it be disclosed to some extent what happens, but it doesn't require the disclosure of the creditor issue or the spending issue.
Got it.
Or the
Okay,
creditor.
thank you for that clarity.
So I might make a suggestion to get rid of lines 156 to 166, and then maybe add a closing sentence right after 155. Because we're saying that 115B is silent. So maybe this might appease everyone to say, as such, further disclosures go beyond the scope of this opinion, or go beyond the scope of the rule.
What were the lines, email?
156 to 166. Yeah, just right there. What's on that?
It's if you have a printed out version, it's 175 on what was posted.
Okay.
Starting with well rule 1.15B. If I'm looking at the right version of this opinion.
That seems right to me.
And what's the motivation? What are we gaining by taking this out?
So
And
that we're
those
not,
who are advocating, hit it out.
Do you- well, we're just explaining the risk
Correct, I understand.
in 156 through 160, the first part of 164.
Right.
But
You're not actually saying that they have to do anything one way or another through there.
But I feel like, why are we going there? I mean,
Yeah.
I see your point, but
Yeah.
like, it's leading us to then doubt
I think you're explaining the gap in the rule.
right.
but is that, that's an opinion, like the gap, like, I don't think a gap in the rule exists, right? So I think that the rule says what it says, and are we reading too much into it by saying, it's almost like Coprac is suggesting that the rule.
There is a gap.
Yeah. There's
I
no.
don't think there's a gap that, yeah. They
Element.
certainly
I
knew
think
how
the
to use.
controversy is with the committee is some believe in the rule or there's a gap and some believe that there's not a gap. And then as a result of whether or not you believe that there is a gap is having an impact on, what should be in this opinion and what should not be in this opinion. So I think, in my personal opinion, to bypass some of this is, first of all, maybe do a straw poll to see, should it be in here, should it not be in here? And then kind of go from there, because we're not going to redo the rule. The rule, it is what it is, whether we agree with it or disagree with it.
Yeah, I think that's a fair way of putting it.
thanks, Vikita. I think you're right. Well, I think.
All right, so,
But so my question still stands for understanding of those who want it out, and you proposed it, so I'll just direct it to you. Maybe I won't ask
Okay.
to try to say what you're done. So what do you think we're gaining by taking it out? With the intent of why we even are having this opinion?
So I think this specific part of the opinion seems to create a requirement, a standard of care that basically says you have a duty to communicate with your client beyond what the rule suggests you do. It's always better to do things that you don't need to do. But when COPRAC or anyone else creates an opinion, it's cited by courts, could be cited by opposing counsel, it could be cited by a bar prosecutor, and they could say, well, COPRAC says you should have done this, but you didn't do this. And therefore, we want to get X, whether it's discipline, malpractice, liability, et cetera. So because our role is not necessarily to legislate or, as the Supreme Court, create new ethics rules, we have to look at the way the rule is written. And the rule is written as written does not require this. Therefore, I don't think we need to get there. So I think Erica's point was, what if we maybe keep the first part of it as an explanatory? I feel that by adding the while rule 115B does not use the term, I feel like that then begs the question, are we then questioning how the rule is written now and suggesting that it's not appropriate? And, that may be a slightly different topic. And I think the answer of my perspective on it.
Thank you.
Yeah.
Do people disagree with the first sentence?
Of 156?
Yeah, starting at 156.
I think people disagree with the rule. But the bottom line, that's the issue. Folks disagree with the rule. So
And wait, while Rowland does not use the term consider, implicit in the
156
requirement that the
is what
client
that says.
sign the
Right.
disclosure is that the client thereby consents to the funds being deposited into the lawyer's operating account and thus assumes the inherent risk of which are not deposited. I mean, I agree with, that's the point, is that
that's just a fact statement.
yeah, I think I agree with that statement, and that's the correct statement about what Rule 1.15 is, that you're telling, like I said, you're telling them, I'm putting in my operating account, that means it's my operating account, it's not client trust funds that, and you're entitled to a refund. Implicit in that is that, I may spend it, and you might not get that refund I'm promising you,
Right.
So that's what that says, I think. And I think but I don't know if we need to go there, is what Emil's saying, because there is a, I don't know, implication there that we're saying that there's a gap in the rule because it doesn't actually say informed written consent.
Well,
It
I
doesn't
think
go-
that's,
Does that imply you need a written response from the client as opposed to a disclosure? Like, I think it gets dangerous.
Right, that language, I agree. Yeah, go ahead, Dan.
I like taking out 156 to 166 partly because there, I don't think the rule has any purpose, but they did make this decision and it's so used by some people. They know the words consent and informed written consent. They've used them elsewhere. This paragraph is sort of arguing against the text of the rule, which I wouldn't do. I don't think it's necessary to do.
Yeah, I agree with that. So should we just take a straw poll of take out 156 to 166? Or yes or no? A yes or no?
I mean, I can guess the votes, but yeah, I think.
A straw poll about having a straw poll.
You might get surprised there.
Could I just ask a question about process before we vote? How long is the public comment period on this? I know in the past we've discussed different comment periods. If this were to go back out, how long would that be?
So there is a requirement within the state bar rules that public comment be no less than 30 days unless there's like a very strong justification, which probably would not exist here. Typically what has happened is the first public comment period is the longest at 90 days, sometimes 60, and then they get shorter from there. We have received feedback from the groups that typically comment on these opinions, including the California Lawyers Association, the LA County PREC, BASF's Ethics Committee, and many others, that's not enough time for them to act to give public comment because of their public comment procedural process, because they have to get together and vote, and then depending upon I think for CLA, for example, it has to go to CLA's executives beyond the committee and so forth. So,
yeah, that's true because BASF has to go through their
board, exactly. So that's why we typically do a longer public comment. Our next meeting is December 6th. I think that would be very tight regardless, even if we did a 30-day to get it posted, turned around, and so forth.
Well, I guess it doesn't really matter.
Yeah, it's not a
Can
rush.
I just add one thing before we vote?
Yep.
So the state bar provides sample fee agreements for attorneys to comply with these rules. And the sample clause that's associated with this exact issue is, it provides the disclosure language, and then it says, having been informed of these rights, the client hereby agrees to the flat fee being deposited into the attorney's operating account. So it's not talking about risks. Even in the sample fee agreement, it talks about the client's rights, but not risks.
But it is informed.
But if they wanted there to be a risk evaluation on either side, they would have said, they would have required some type of disclosure with risk, and then they would have put, having been informed of these risks,
Yeah,
the client agrees to proceed, because that's what they do in every other.
it's very deliberate.
Well, it is.
There is a deliberate
just-
reason. Yeah.
Yeah.
Since I think I know what you're going to ask, who that they was. That was the mandatory fee arbitration committee that drafted those sample fee agreements.
Wasn't that Joel?
Yeah.
But that is what the state bar, that's what the Office of Chief Trial Counsel looks at as the gold standard when we're talking about enforceability and public protection of these.
That's good.
helpful.
Yeah, that's good to know.
Yeah, it's about clients' rights, not about the risks.
Yeah. Okay, so and that's more reason why we want, well, I want
Some.
of us. No, I'm not trying to sway anybody. Okay, so should we take the straw poll?
So a vote, what's the ask?
Yeah, what's
The ask is, do we want to remove it?
156?
156 to 166, no. Do we want, so it's a yes or no vote?
Okay, so if you vote yes, it's to remove 156 through 166. If you vote no, it's to retain it and recommend the possibility is disclosed. So that's, we're not creating a new obligation. We're just saying that it's
If we
recommended.
land on no, maybe we can have some further discussion on how to revise it.
Sure.
Yeah.
If we,
If the language
Say
is
we want to
maintained.
retain it. So
Right.
no, we're not removing it. No is we're not removing it. And then we would
Yes
have
is-
further discussion about wordsmithing. Okay, so do I do this? Who does the word or
I
the?
could take the roll. All right, yes, it's to remove. No, it's to keep. Ali,
Yes, please.
Brown,
No.
Bradley, Coleman,
No.
Guzman, Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter,
No.
Robbie,
Yes.
Riley,
Yes.
Chambers.
Yes.
We'll move it in.
6 for yes and
3, 2,
3, 2.
3.
Can I
Yes.
request a straw poll later on, as to the appetite for a scathing critique of Rule 1.15 standalone?
What?
I like it. I think it's fine, the rule.
You mean in the opinion or
No,
to-
no,
to
not-
create-
Totally separate.
We can do an
separate,
ethics,
separate.
you can do an ethics quarterly on it, right? Maybe.
No.
Or you could amend the rule as I
That's
think
what I
what
wanted
That's
to
what
Bridget's
he said.
suggesting.
That's what I
Right, right. Because I don't think, just
I
because something is, doesn't mean that New
Yeah,
Thought can say we should relook.
The
this.
rule is very specific, I mean, again.
It is very
specific. It went through the Rule Revisions Committee. You gotta think they discussed this in.
Well, we don't have to think they did it right.
Well, are there like legislative history comments?
They
There
did
is,
it,
like,
they
you
did
have-
it according to their right.
Legislative history on it.
Yeah,
You want it right now? I have it.
Come on.
yeah, I mean,
Right here.
there's a reason
No, I know
why.
there is. I know there is.
Which is,
I don't know. I mean, well,
Okay,
because
well,
it's
we're not gonna
implicit
keep
in the
things
rule
about
that there
what
is.
there must be.
You can't,
Debated.
yeah.
I'm sure it was.
I don't actually have a.
Anyway,
You're giving the halo effect. Those smart people must have.
I
thought
just
about
think it's
these
such an
things.
obvious discussion to have about that particular rule.
I totally agree.
It's a big one.
Yeah.
It's,
I will
Yeah,
just-
but you got different, you don't know what the mix of the committee was.
It's fair.
Right?
It's possible.
If you have more public members, you're gonna come out with some different sides of that conversation.
And the committee's charge, going back to what
Different-
Emil
different.
said, was to review the California rules.
Right.
And have them be more similar to the ABA model rules.
Oh, right.
Unless there was a reason for them not to be.
Right. So
And
different
so-
That's the
objective,
point,
different
I think.
objective.
Yeah, we would be
right.
going out on a cliff, or going out on a limb, not a cliff. Over the cliff. If we change the rule to such an extent, because it's not in any other rule.
But half the states have a rule like
That
we
you
used to
do
have,
do.
that you can't do this.
Right.
Yeah.
But the
Right.
ones that do don't have a disclosure of risks, so we would be going one step further.
Yeah, or they have an opinion that allows it or something.
Right.
Yeah. So there's
There's
different
ways,
Yeah.
yeah.
But going back to this issue, like as somebody that's licensed in multiple states, and I think some of us might be here, and that practices in multiple states, it is very confusing when you have like
Right.
our rules
Different
here, especially
rules.
like, you're like, I'll look at 1.8. No, I got to look at 1.8.1.
Right.
And it is already confusing. And my thought, and again, I'm biased here because I represent lawyers and I represent lawyers that get in trouble. My job is to make sure they don't get in trouble. You can't rely on people to look at the rules and understand them. That's why we have opinions. So when I see an opinion, I'm like, one of my critiques in general is I would love to have like more of a very short digest that really answers the question. Like, if you ever seen a good expert declaration, it says what the question is and what the answer is, kind of like the IRAC or CREAC method, whatever you call it, from law school, right? And I really like that, like to get to the point. The downside of that is somebody might just read that and not read the rest of it.
Yeah.
We want that too.
Yeah, that's what we're trying to do. But that's good. I mean, you have a good perspective. I forgot that you had other licenses, and you bring a lot to the table here because we're so California centric here, as we should be, but.
Okay,
Okay.
so I think, Angela, you can remove 156 through 156, the 160.
Slow?
Yeah, then, no.
Is it, does it make sense to just do that?
So scroll up to the
It's
next.
so funny because the sentence right 153 says it's silent as to whether they're required to disclose the adverse consequences. Like it's like we were.
But these aren't the opinions typically go beyond the base level of discipline or interpret.
No, but it's funny. It's funny that it's like
Yeah.
it says it's silent to it, and then we like opine on what we think the silence.
Yeah, what fits in that
Same.
silence, right?
The pregnant pause or whatever.
Yeah, that's what you get to do.
Okay, so well, but it's not that it's silent about a lot of things. What it says is what you should say. Like there's this, I mean,
Right,
I don't know.
but we
We're
say
rehashing everything.
But we say it's silent as to whether they're required, and then the conclusion of the next paragraph was, it's our opinion that it's required.
Yeah. But I don't even like this sentence because it implies that, you know, that there's something in that silence. There's something, you know, there's something
risk.
implied by that silence. And
There's
so,
risk in that silence.
yeah, like it is open for interpretation and expansion. And what we're saying is, no, the rule is very specific. This is the disclosure rule, you know? And so
That's why I think you have to delete
More.
the whole thing.
I think you need
You
to
have to-
delete that whole paragraph, because that paragraph, if you end it there,
Yeah.
you're explaining the risk and you're saying, great, let's move on to the next section.
Should we are you saying we should delete all of A?
No, I think you're deleting at least from 149.
Let me go back and.
So
Can we, here's a suggestion, can we take a little break and can we all just sit down and read that section? At least I need to reread it.
yes, of course.
And
You're the
I
chair.
also want to go.
You are the chair.
Well, I also want to run to the restroom. So can we take like a 10-minute break and then sit down and read this and then just make a decision as to what we're going to actually remove and then maybe run this straw poll again?
Sure. So it's in the posted agenda materials. It's item 4.3. And we're looking page 4 of the red line version, starting at line 149.
But I think to get to the red line, you have to go to the share.
It's on the publicly posted agenda materials. It's that I can help with as well. It's a little.
Because that's where I have to go to get it. So.
Sorry, I didn't make you feel more.
Okay, so we'll reconvene and let's do 11:45.
Okay, I'm going to pause the recording. Okay, so I reread the section A, and my thought is that we keep all the way up to 155 and change the last sentence. So the last sentence that says, however, Rule 1.15 is silent as to whether a lawyer or law firm is required. I would change it to, however, the plain language of Rule 1.15 does not require a lawyer to disclose such potential adverse consequences if the flat fee is not deposited into a trust pending completion of the work and the fee is earned. Period. End of section.
Instead of plain language, could it just say, however, Rule 1.15B does not
require? I don't know. Well, because now we're making an affirmative statement.
Well,
you don't have to disclose, you know what I mean? Like
You
it's,
guys have swung the other way.
I know, exactly. So that's why I thought like plain language, somewhat like silent, but a little, I don't know.
I think
That
it
was
says
my
the
thought.
same thing, but less clearly.
What if we didn't say anything about it and just stop after the word creditor and then strike everything after, like the however sentence, the last sentence? Is that okay?
Where are we? However, okay, so.
What lines, Brandon?
152 in the red line, I don't know.
That's okay, yeah.
So my earlier suggestion was to say something that it was beyond the scope of the opinion or beyond the scope of the rule, or both. So, because I
like
think
that.
it's a closing sentence, but.
I like that. I like Erica's change and any, and then saying, anything beyond what the rule requires, or, anything above this is beyond the scope of the rule and this opinion.
Yeah.
I mean, because Spencer could want to say, like, you can do it if you want. If you think it's.
Like the fact that it says that Rule 1.15B is silent. I think that is.
You like
actually
that?
helpful, yeah, because what we are
Because it
calling
is.
out that it's not.
It is.
Oh, do you?
Well, let me talk out loud, right? Like,
Yeah.
so if we're saying it, what are we saying? We're just saying like the obvious, right? That it's silent. It could signal to somebody that maybe there's something missing, but it could also just say, hey, there's no additional requirement.
I think that when you read, ethics opinions or court opinions that say such and such rule is silent, it usually launches into an interpretation as what that silence
I
means.
see. Okay.
And so I don't want to go there.
No, fair enough.
Yeah. That's why I like 1.15B does not require, and then I like your suggestion that we say, additional disclosures of particular risks is beyond the scope of the rule in this opinion, something like that. Does that make sense?
I'm on board.
I like that.
Okay, so.
Can I just say something that I think maybe in some way, I guess, will negate the need to go as specific or trying to split the hair is kind of when I'm listening to us speak and to whom we think this is directed, I don't think they even know what a trust account is or an operating account. And so in some way, we're trying to say it's a risk for them to avoid. But
Who, like the client? Are you talking
yeah,
about the client?
again, the level of sophistication.
Well, but I think what we're trying to do here is give some kind of guidance to
The
the
attorney.
lawyers. Yeah, I mean,
Right.
this is like, because what I think what we're trying to say is, this is not a
I
requirement,
agree.
period.
I understand that.
But, you might feel the need in your particular situation to actually disclose the
And
risk.
so what I'm saying, so I agree with that, but what I'm saying is that it implies that the person that you're speaking to knows the difference. And what I'm saying is that for the level that we're trying to even talk about, because again, the person who put a $560,000 advance payment, they know, like, they already know this, and so I realize we're
Well,
we're
now
speaking-
we're going way back. Now we're like talking
No,
about
no,
like, do we
I'm
have
not-
to tell a client?
I'm not, what I'm saying is you don't, and even the level of specificity that we're trying to split hairs about, it's going way probably over the head of the person we're trying to protect. Because we know what a trust account is and we know what an operating account is, but the people you mentioned that you see on the courtroom floor and they're just looking at the lawyer who was in the courtroom and saying, can you help me? They don't know. Like, it's just, that's
Well-
just not, they don't, their level of,
Go ahead.
they don't have money. I mean, they basically don't have money. So they don't know the difference between an operating account, a trust account, or whatever. They're just looking for somebody to help them. And so, yes, we can, but in some way, I'm advocating to say to you guys, trying to wrestle with this in some way too much.
I think if
Doesn't.
you're dealing with a client who doesn't know the difference between an operating account and a trust account, and you're dealing with 1.15, that you would have an obligation to explain that basic difference to that client, that particular client. Like, you
But
can't
we're-
have a disclosure if they don't understand the basic thing, like 1.15. So, but that's beyond the scope of this opinion too.
So, the audience for this opinion is attorneys.
I
right?
agree.
And so I think the committee saying the committee does not opine on something
It's fine.
is opining on something.
Right, right.
Saying we don't want to go this far. So perhaps taking the however sentence, and you could say 1.15B does not require a lawyer or law firm to disclose such potential adverse blah, blah, blah.
So,
But a lawyer, I mean, basically you're saying
Right.
a lawyer may, but is not required to, is what you're really saying here.
Oh.
I think
That-
that's more valuable than
we
does
like
not
may,
opine.
but is not required.
Right.
But that is going in the opposite direction. It's kind of affirmatively saying, it's a very, very firm point, that the rule doesn't require this, but you
But you
can.
may, right.
But that's what we
Which
want to
implies
say.
me is in some circumstances have a duty.
Okay, so
And
then.
they like to consider.
But the may is clearly saying that you're not required to.
Right.
Now, just to play devil's advocate to what you just said, about how a 1.15B disclosure requires you to explain the difference between a client trust account and an operating account to a quote unsophisticated client, whatever that means.
Someone who doesn't know.
Isn't explaining the difference between those accounts, isn't that the primary difference between those accounts to some extent?
What?
Is that you're holding the money on behalf of a client in a client trust account where it's safe for the client and cannot be touched. And if you're holding it in an operating account, it can be touched.
Yeah, but if, I know, I mean, I know
What's
we're
your
like,
point,
it's,
Erica? Wait, what do you
because by
mean?
explaining the difference, basically you're saying, and I said, you, of course you would have a duty if they don't even understand the difference between the two accounts. And you're saying, well, does that mean that you're then explaining the risks?
Yes.
Possibly, but like if you're dealing with somebody who just literally thinks that they're exactly the same thing, an operating account and a trust account, you have a basic, like it's like a basic duty to just get on the same page with your client. I mean, that's like I think that's more of a 1.4 disclosure requirement.
Which is what Joel put in it.
I know.
So we are just
we're kind of circling back.
One
But
point one five is a violation over 1.4. That's what I think.
I agree.
What?
wait, what?
Whoa.
That's from my later straw.
Uh-oh.
I mean, it does what we're just talking about does highlight this problem. I
So,
get
and my
it.
only thing is that I would suggest, rather than like oblique references to our discomfort with this gap in 1.15 peppered throughout a bunch of opinions, we consolidate our thoughts, direct it at 1.15, and then streamline this opinion and clean it up to get out. That's just.
I know, I think,
Yeah.
and I agree with that. That's fine. And we can have this fight for another day because I don't know if I want to revise 1.15 even, but but yes, I think that we're just, we are, at least I am going in circles. So right now, I think the question is, do we want to put may but is not required to, or do we want to put not required to and, disclosing risks is beyond the scope of the rule in this opinion? Those are, I think.
So if you were to wordsmith what's on the screen, it would be under Rule 1.15B, a lawyer may, or a lawyer or law firm may, but is not required to disclose such potential adverse consequences.
What if we just said does not require and risk is beyond the scope?
Well, that's the alternative to this, right?
Yeah.
I think I like that
better.
better. I think may, I don't know. I like now we're like over wordsmithing, I feel.
Should consider.
A lawyer or
No.
law firm may,
That's what we just left.
but
Yeah.
is not required. I like that.
No, we got rid of.
No, we got rid, no, I think no.
It did say it was.
That's like a best practice. That's like we're recommending. And we're not recommending here. We're actually just saying what the rule says.
However, it would be under as opposed to however.
We put as written 1.15.
Well, that's why the plain language. That's what I was thinking too. As written.
As written.
That's under Rule 1.1, a lawyer may, but is not required to disclose such potential adverse consequences if the flat fee is not deposited into a trust pending completion of the work. I mean, we could. Okay. I'm going to say
But
this.
it's not required because I think
Yeah.
it might actually go too far. If we're agreeing that there could be circumstances under
That's what I'm saying.
communication where a lawyer should,
But
we
by
don't want to say it's not required. It's beyond the scope
Should
of
we
the
ex-
opinion.
well, I know, but here's an idea that I know I'm circling back. A lawyer or law firm may, depending on the sophistication of the client.
But what does that mean?
Yeah, no.
I
But
mean,
that's what we're saying.
That's also not in the rule. That's not in the rule.
Yeah, I know.
What about, say, like, under the other duties owed to clients, under other rules may implicate that
That's
you
an
should
idea.
Disclose.
Like, while it's not.
Other
here,
rules may
there-
implicate.
Other rules may implicate.
Like if you have a creditor levying on your account when you're taking this money, maybe
Right.
that's a material development you have to disclose.
So we should just say, for example.
I think what Carrie said will
That's not good.
suffice.
Yeah, just like under this rule, it's not written under this rule, but it
But-
may be implicit under the.
Or
other-
require, or maybe require.
It may be required under the other rules.
Oh, under what rule.
1.4. I
1.4.
still think 1.4 comes into play.
Yeah.
I agree.
Yeah.
And 1.4 is what specifically?
It's a significant development relating to the representation.
Which
So what
if
what
you-
is the
I ran out of
development?
money and I spent it all and I'm never gonna have the money for your refund.
But this is
No.
about,
At the
this is
beginning.
about, yes, this is during the formation of the relationship, right?
This is about the agreement.
And so unless you right, but that's not what this opinion is about.
Right.
So I absolutely, if
If that happens,
on
material
May
change.
1st, you
Right.
execute this, you provide this disclosure,
And June 1st.
June 1st, you suddenly have a creditor.
you should
That is a
just,
significant
I think-
development.
Right, but right. I mean, I think either and we don't have to spell this out, but at the beginning of the formation, let's say you are dealing with a super unsophisticated client, I think that falls under 1.4. And then if you are, working, I don't know, paycheck to paycheck, I mean, the business equivalent of that, and you struggle to pay your bills, and there's a reasonable risk at the beginning of the, that you're may not be able to issue a refund. That could be a significant development. There are particular circumstances that we wouldn't have to spell out here where 1.4 does come into play at the outset.
So if this opinion is going to help lawyers determine this, should that be in the opinion?
You have a duty not to, I mean, if you have a possibility of having to refund money to a client.
Wait, what?
There's no specific duty to keep the money in the operating account.
I understand that, but you need to be able to repay it one way or the other, right? So it's.
So I think that's a whole other either section of this opinion or opinion that says, like, if you are no longer going to be able to return advance fees,
Right.
then you need to, that's a significant development relating to the representation that would need to be disclosed. That
doesn't touch here because we're talking about formation of the.
yeah, and it doesn't explicitly exist in the rule. So we're back to, again, to make this as circular as possible, are we creating a new duty?
No, but does 1.4 apply at the formation when you're dealing arm's length with the
So the
client?
problem is the Alderman versus Hamilton, right? Isn't that everything in a fee agreement, even at the arm's length fee agreement, has to be explained and any ambiguity is construed against the attorney.
Right, yeah.
So we have a bunch of inconsistent concepts here. This whole arm's length at the outset is great, but it doesn't mean you can take advantage or.
No, but do you have to, my specific question is does 1.4 apply in that negotiation of a fee agreement? I don't know. I honestly don't know the answer, if anything, that.
Dan's off mute and Novella had her hand up, I think.
Sorry, I don't know.
I don't think so. I mean, in part because what are you really communicating? Potential risks that, the sun might explode. That's another one. Put that on the list.
Is it a 1.7 conflict?
Oh,
Right.
Which is-
Implementation.
Right.
Is it a 1.8.1?
it's all of the above.
It's all.
So
Novella.
So I'm not sure about 1.1B, so I take the point that 1.1B does not use the term consent or informed written consent. But then I went back to the definition of informed written consent, and it's weird to me that it just means disclosure in writing, and that is the phrase that 1.1B uses. So I'm wondering if it matters, even though 1.1B doesn't have like consent or informed written consent, but it's literally reciting the definition of informed written consent under 1.0.1 E1, which is
Read the whole definition out loud.
informed written consent means that the disclosures and the consent required by paragraph E must be in writing. And then paragraph E defines informed consent, and that talks about like the relevant circumstances, the material risk, the things that we thought 1.1B didn't include.
Wait, okay, so let's go back.
Strictly speaking, in terms of obtaining written, the informed consent from the client, which implies the client is the one giving the writing. I shouldn't say usually, some of the rules, at least.
And then.
But yeah, I mean, like traditionally in the ABA structure, it's informed consent and then confirmed in writing, right?
Okay.
And that's why like conflict waivers don't always have to be a signed agreement. It's just something that you follow up in an email. But I think paragraph E, the definition of informed consent, really hits this home. It's an agreement to a proposed course of conduct after the lawyer has communicated and explained, all that stuff. But that's not what's written in 1.15.
Yeah, so I'm looking first at E1. So I thought disclosures in writing, that language of informed written consent seems to match the phrasing in 1.15B, but then E1 has that, but then it also references paragraph E. So I'm asking how much of paragraph E matters given the overlap between the disclosure language in 1.15B and the definition
So
here.
Well, I don't,
right.
1.15B is missing the word consent, which is, so it's not a match for E1.
Yeah, so writing is separately defined later in 1.0.1.
Okay.
And I mean, just go back to.
That's what it's
If they
referring
meant
to, yeah.
informed written consent, they would have said informed written consent in the rule.
That's fair.
Yeah, I mean, but,
Separately defined.
right.
Yeah.
But the predicate to E1 is E, right? So to get E1, you have to have E. That's the way I look at it.
Okay, so where are we?
I think we are at the committee does not opine on whether a lawyer needs to include this in the disclosures.
So put that at the end of the sentence, and we're gonna keep may, but is not
No,
required.
you're suggesting replacing what you offered originally,
Oh, I think that's what others in the room want to do.
which would be a change to what you had offered,
Correct. So I think it would be undoing the current.
which is basically you may.
I think we add that sentence. The committee does not opine. We can have may, but is not required, and then the last sentence should be the committee does not opine on.
Isn't that the same as saying may? You have to really reduce some of that.
But we're not making it, it's not a recommend, it's a neutral phrase, may. It's not a recommendation or an opinion you don't have an opinion on.
But it's not required is the part of the phrase I have a problem with.
Wait, what?
The but is not
Yeah,
required
because there's.
is the part that I'm concerned about.
Why?
Because you're saying it's not required, but we've all discussed that under certain circumstances.
It could be.
We might
But
think it is required.
Oh, but what about
But we're actually, what we're saying is it's not required under 1.15B.
Well, that's fair.
But it could be,
Be like a-
but
I forgot
Karen
about
said
that,
it
yeah.
could be required under some
well,
other.
that's
Dodge
fair.
this
So it's
issue.
susceptible
This is
to
fun.
misinterpretation.
Carefully dodge this issue.
Yeah, okay, so, but we could say something like, the committee
But
cautions
maybe-
lawyers to read all the other rules to see if there is a requirement.
I think you're saying a lawyer may have an obligation to
Under-
disclose this.
Under other
1.
rules.
Well, I think, but we should point them to the right rules
Okay.
instead of saying, here's 90 of them to look at.
Okay.
I don't.
But people don't agree with that.
Yeah, and sorry, but like, I guess my point is, then, again, we're trying to say, hey, there might be another rule that's applicable. So if I read that, I'd be like, oh, okay, I think they're signaling that.
It is
Just check it
applicable.
Oh my God, where are we gonna draw the line, you guys? I mean, so
I mean, I'm okay with this language here.
may but not required and
Yeah.
leave it.
I
Okay.
mean, I
I
know.
It concerns me a little bit. I mean, is there a way that you could read 1.15 as requiring it?
No, but it
I
says,
don't
the
think
rule-
it's not
1.4.
it doesn't say the rule may require, it says a lawyer may do this, but it's not required.
Can we
I-
put, but see rule point 1.4?
A lawyer.
Rule point
Under-
1.4.
I like that formulation. I apologize, I couldn't see who in the room had proposed it, but the formulation of other rules here may kind of counsel in favor of these disclosures, including 1.4 and just leaving it at that. Was that the suggestion I heard in the room?
Yeah,
Loosely, yes, Carrie.
but some people don't
Just
like it.
broader.
Counsel in favor of is pretty good.
I like that.
When
I
we're
like that
dodging
phrasing. Yeah.
Something and trying to be neutral. That's
Yeah.
pretty good.
So wait, say that again, Deepika?
Yeah.
Other rules may counsel.
Other rules may counsel in favor of providing such disclosures, including Rule 1.4.
Yeah, for example, rule 1.4.
Okay, so
Can we write
that's
that?
one.
That's a
right?
good
Yes,
one.
That's one
Just write
option.
that out.
Other rules.
Can you get it?
Okay.
Angela? Thank you.
Other rules, yeah.
May counsel in favor of such disclosures.
Is that what you said?
Can I rule counsel?
I think it's.
If read
okay.
properly.
Yeah.
And then you would put C rule 1.4.
Other rules may count, so.
CEG. Are there other rules? No, you don't.
Well, because you just really want to say,
There's
for
no other
example.
disclosure rules that would apply.
I mean,
I mean, theoretically, 1.7, 1.8, right?
Right.
Theoretically, but, so.
and
that-
6148.
Oh, yeah.
Oh, see other rules and statutes?
Business. So
Right.
another way, sorry to read this, is to say, instead of starting with under rule 1.15B, it says a lawyer or law firm may, but is not required to under rule 1.15B,
Oh, right.
Disclose. Right.
because then we're changing the subject.
The emphasis.
Well, should we take out under rule 1.15B and just start with a lawyer or law firm may, but is not required to under rule, so we're not being redundant? Is
Yeah, exactly.
that what you
Right.
said? Okay,
Right.
yeah.
Yeah, that's what he said. And it puts the emphasis on the lawyer, not on the rule.
Joel's
Right.
gonna see this and be like,
He's gonna have a hard
oh,
time.
man.
I think
He's
you
gonna
can-
say, I should have come.
I think you can remove the two. So I think it's a lawyer or law firm may, but is not required under rule 1.15B to disclose. I
You
think
could
the
probably
two
put
is
comma
a.
before, under, and after.
What about wow?
while,
Oh, while.
while,
Wow.
or although. That's
Well, I don't-
while or although is another one, which or that.
Unless they change the other.
I think this is.
Oh, yeah,
okay.
is there like a rule for when you're supposed to use?
Is although or while, yeah, and I'm, that one I'm a little fuzzy. I think,
So a lawyer.
The aforementioned
may, But
notwithstanding.
is not required to
I-
under rule
I-
1.5B,
I
comma,
hate.
disclose such
Mhm.
potential.
Before going.
But it's not required under rule to disclose such.
What if we said something just like this opinion does not address whether risk disclosures or potential for adverse consequences, disclosure of potential adverse consequences is required or appropriate under particular circumstances, which I think suggests it might be. Like, I think it actually might be clearer to say that.
Can you
we
add,
just-
what Eleanor said?
let's just
as
put that
another
below
option?
this and then let's look
Yeah,
at
let's
it.
add it, just to hear, just to see it.
Can you just put it underneath at the, see, after C rule 1.4 as a standalone statement? Like,
Maybe, can
hit-
you
hit
restate it,
enter.
Eleanor?
Yeah, this opinion does not address whether risk disclosures as a shortcut are required or appropriate under particular circumstances.
Yes.
This opinion
The
is
other-
not just
The other weather,
whether,
whether,
Risk disclosures, we can change that to disclosure of potential adverse
we
consequences.
can not just whether risk disclosure
But
is
if-
Are
required.
required or appropriate.
If not this committee, then who?
Well, we can deal with it. Like, I think it's a fair thing to
Are
raise, but are we
required
going to deal with
or-
it here? I think it's the question. And now.
right, we're not saying this committee, we're saying this opinion.
We should reserve all rights to attack rule 1.1.
Yeah, and we reserve, and the committee reserves all rights.
Whether the risk disclosures are required, or what was the rest of the sentence?
Or appropriate
Or
under
appropriate.
particular circumstances.
Under particular circumstances or other rules of professional conduct.
When those rules would apply.
So,
That's not in addition, that's alternative language.
Yeah, yeah.
but
Right.
just to back up
Yeah.
for a second. The purpose of these opinions is to clarify the obligations
Right.
of lawyers.
So don't be
Oh,
wishy-washy.
God.
Is that I don't think anything
Is gained by this?
in from 153 on, frankly,
Is helpful.
That's helpful.
is
It's
helpful.
clarifying.
Helpful for a lawyer.
I think the last sentence is really about, we're not opining on this, is
Then-
what it says, but you might want to think about it.
Right, but the
And then-
heading is
so should we
risk
say more
disclosures, and
about
we
what
gotta
we-
say you don't have to do it. I mean, you know what I mean? Or take out that whole section A.
Well, I think that was what I suggested.
Time ago.
I think so. I think you can, if you scroll up for a moment, Angela, thank you. Keep going.
To A.
I think if you just stay there for a second. Oh, so this is what paragraph 1 and paragraph 2 of this section are required by the rules.
And then we.
These are this is not controversial, but the heading is about risks.
No, it's about disclosures,
Let me see, go up.
disclosure of risk.
Disclosure of
Right.
risk.
So I think we're talking about disclosure of
Maybe it's not.
like required disclosures for depositing. But then if you just scroll, don't make any change, just scroll for a second. You have rule 1.15B, you're explaining what happens here. It's unearned. It's subject to refund. And then if you take that thus sentence right below,
Next one, right?
you could just have that sentence that explains the, there is some risk. I think you would get rid of the thus. There is some risk to the client and an ethical concern for the lawyer
Why don't,
when they can't refund the money, and attach it to the paragraph above.
why don't we put it in a footnote?
Sure.
Wait.
Just take that and put it in a footnote. There is some,
Why would you want to put in the footnote?
because I don't know, I think it reads better. Because we're, the main body is, this is what the disclosures require. Nothing more, nothing less. This is what we're saying. We're not being, we're being very tight in what the rule, what we're opining on what the rule says. Basically,
Well, we're actually not. We're just restating
stating
the
the
rule
rule,
in
I
two
know.
paragraphs instead of
and then
three
we're,
sentences.
and then I guess we're saying that, in a foot, like, I think a footnote just takes it out of the controversy. Or minimizes the controversy that we're struggling with.
And it is sort of our typical place for saying, for where we say we're not opining on whatever.
Yeah, I mean,
I think a footnote solves it. I mean, because it makes it less important. It's not critical. It's another thing to consider.
right.
I mean, wouldn't a reasonable lawyer look at that and think, well, if this is a material risk, then I probably should disclose it. If it's not material,
Right.
I should disclose it.
Right.
We're writing this for the reasonable lawyer?
Right. I mean,
Where are they?
is it the lowest common denominator lawyer?
That's the tension.
That
Right.
is the
It's
change.
really the tension. It's
Yeah.
like, how much do you lard it up with stuff that should be obvious to the reasonable?
Right, like the ethical lawyer.
Yeah.
But
Where are they?
they're,
Oh, they're here.
and
Oh, they're all on the committee.
They're all the- they're
well,
all
and
the-
the only people who read these opinions are the ethical lawyers, because they're the
Exactly.
ones that,
Yeah.
Are concerned about.
Or the people that are already in trouble.
or the people that are and
But
have.
that's the idea of making simple, clear opinions is that, but the problem is how do people find the opinions? That's the other thing.
Well, that's a whole other
They're gonna
issue.
argue with me because they want to do something unethical, and then they're like, "But Copac said this."
Is that what happens?
Yeah.
Represent both sides of it.
What?
The concern with the footnote is that if it's important, people don't, I mean, they're already excessively long. And so you don't usually read a footnote. It's like you think of a footnote
I
as
read
something
footnotes.
not, but
Actually,
again, you're the
footnotes are-
one that this is geared towards, right? And so we're trying to, if we're trying to make them
So-
more precise and the things only that we want people to look at. So I think your rationale for why you want to do it should question us doing it.
Why?
Because you said it's sort of controversy, so let's put it over there where people won't really notice it. It won't be part of the opinion.
No, don't.
That was
That's a
your
long-standing
words.
tradition in law.
That was Cassie's words. So I'm just.
No, I
Explain back
was
what you said.
inarticulate. I like what Emil said and somebody else said about why somebody
He likes what
no,
he
I know,
said.
maybe Dan said about the footnote. That's what I meant. I don't mean like, oh, we're skirting a controversy. We're just saying exactly, we're not going beyond what we're comfortable opining. But the footnote does what Dan said. It says-
What Dan
it
said.
does
What Dan
identify, that there could be a risk. And I like what Eleanor said, which is, if it's a material risk, a reasonable lawyer is going to disclose it.
So Ange, what we're looking at doing is if you, that sentence, just through creditors,
And all of that is out.
scroll up more, just through line, there. So that would be converted to a footnote.
Okay.
So just copy it.
And you want to put it at the end of.
And it would go at the end of line 140, there, at the end of that, that'd be a
I mean, this issue might be good for one of the quarterly alerts, just to kind of get the thinking going, see if we want to revisit it at some point.
Yeah.
And then the first
It's
sentence.
addressing the
To dig into
disclosure
this,
requirements, like
but-
we really, I mean, I want to know, like, is this 1.15
Every time, insert.
I'm trying to think of what other disclosure requirements there are under the rules that are not informed written consent. I mean, there's 1.7 that is just non-conflict disclosure, like family stuff,
Relationships. Yeah.
relationships.
All of line one.
That's the only one I can think of off the top of my head.
The whole from
Business.
oh,
the whole
through 157.
Yeah.
Like,
That's under.
Business and transactions with clients.
Transactions.
That
That's a-
that requires
But
a
if it's
report.
a business interest that's just merely like relevant to a representation, it's just a disclosure.
That's a 1.7 still
Yeah.
though, right?
Topeka has her hand up and just, it's
just-
really hard for the people watching to hear us all talking at the same time.
Got it.
Thank you.
Topeka.
Just wondering if we should change the title slightly of this
Yes.
Right.
section. I think it's now real focused on disclosing the client's rights rather than the risk, which is
So-
also, I think, the mirroring the
Right.
language of 1.15B.
So would that be required disclosures for depositing?
Yeah.
And advance, yes.
I think this strikes the appropriate balance of what we're like.
It just says the rule, doesn't
But
it?
it says the rule, but we're just, there's something, I mean, there's something that needs to be said about this whole idea of, well, what happens if you can't give back a refund? You know, and we are addressing that in a very diplomatic way, I guess. Well, I like it. What about you guys?
I see nods on the screen.
Yep.
So if there's no other discussion, I think it would be a question of whether the group wants to send it out for public comment.
Okay.
And for how long?
Let me just see what the end of it is. There's some risk.
We would have an option not to.
Oh, no, it has to.
Okay, you mean if we want to send this as it's written? Okay. Modified.
You know, this is
If there's a more
a
modification.
substantive change
Yeah, okay.
since
All
the
right.
last version.
I just didn't understand.
Yeah.
Like I thought.
The
we
comment
had-
is going to be from Joel, who objects to all this, basically.
Of course,
I know.
but he didn't come, so
No, he'll do the public comment. We're
that's
gonna-
okay. He
The
said
former committee member.
a former member. He said he's leaving it.
And a former, he's mandatory fee arbitration committee and
Said I can't.
now
do it.
co-pride, or formerly co.
We'll do go revise the form. Like sample fee agreements.
And where's the footnote? Right,
Uh,
is it number 2 now?
yeah, that's the
The one that we took in. Okay. There's a risk to claim.
Do we want, does having the footnote, and I'm not really sure, but does having the footnote without a comment that we're not opining on this suggest that that's a tolerable risk under all circumstances? Disclosure is not required. I don't know. Does anyone have any thoughts on that?
It's also not just an ethical concern, would be my other feedback on that sometimes.
Wait, say that again? What do you think?
It's more than just an ethical concern.
It's fair.
What do you mean? It's a, what else, what do you mean by that?
Well, I guess ethical, I mean, I guess you could read ethical more broadly.
Yeah,
It's a financial,
right. I mean, a financial concern for the client.
and possibly the
And for
lawyer.
the lawyer as well. Yeah, for
But-
everyone.
But that, I mean, that like financial could fall under ethical. There's some mess of them.
You can remove, and I don't think it adds anything to say and an ethical concern.
Yeah, right,
I think risk to the client and the lawyer.
right.
when the lawyer is terminated.
I feel like every time I speak, we're like just go into circles. But I feel like, in this situation, should we be giving them guidance? Okay, then what? If this happens, what's going to happen to you, lawyer? But that's not what we're talking about. We're just talking about the beginning, the formation. Yeah.
The disclosure.
Yeah.
So in footnote 2, the proposal is there is some risk to the client and to the lawyer. Is that right, Eleanor?
And for the
I was
lawyer,
actually
and for
thinking
the
there's
lawyer,
some risk
and to the client and for the
that
lawyer,
when a
right?
lawyer is terminated,
When the lawyer,
the lawyer may be unable to refund all or a portion.
Oh, yeah. There.
So
So
you-
it'd be there is some risk
so you don't need to because you already really have.
that, not to the client, you'd remove that as well.
Yeah.
There's some risk that,
When the lawyer is-
If a lawyer, I guess you could say.
yeah, that if a lawyer is terminated, you
What
can
is
delete a
that?
lot.
Complete.
So, and yeah,
The lawyer may be,
Unable.
I guess it's when and then if.
there's some risk to the lawyer if a lawyer is terminated
When the lawyer is terminated before the services are.
and it's and is
And
unable to timely. Because that's the risk.
That is right.
It's not there's no maybe risk.
Yeah.
And I think it's or have become unavailable.
Yeah, I think you could start with if a lawyer is terminated before the services are completed, there is some risk that lawyer may be unable to.
So if a lawyer
Who's terminated.
there is some risk.
There may be risk.
So comma after completed. That the lawyer, right?
Sorry.
Then it'd be may be unable, back to may.
I would just strike the that. I always try. There is some risk the lawyer. Maybe that.
First sentence, yeah, right there.
Dan, did you have?
He's gone.
He's off mic.
No, thanks. I'm good.
You go up to see what this footnote is tied to one more time, right there.
I kind of feel like we should add a sentence to the footnote that says that this opinion does not, or this opinion does not address disclosure of such risks or something like that. Back to where we were. Does anybody object or agree that we should have some kind of sentence like that? I just feel like it's still just kind of left hanging. If we don't have something that talks about why we're putting this footnote here, or why we're just talking about risks now in a footnote, when we're only talking about requirements, required disclosures. Yay or nay on that sentence?
I think that works for me.
Okay.
It's again, the footnote concept is just something else to think about, not the 1.15b question necessarily.
Okay.
And if your assets in the firm are going to be attached by creditors, you're not going to make any disclosures anyway.
Right.
Right.
Okay. I think I'm good with that.
Do you think there needs to be a comma after advance payment on the second line of the footnote?
Yeah.
Between unavailable and because in there, could we put just for example? Because that's just one example and it's not even a very likely one, in my opinion.
Right.
So, unavailable, comma, for example, comma. Like that, Dan?
Yeah.
Just leave it.
I did a great job.
Should we vote it out?
If that's the committee's prerogative.
Am I? Well, we're a committee, guys. All right, yeah, I mean, I'm happy with what we have here. Speak now or forever hold your peace before we vote it out. Does anybody have any other suggestions, revisions, objections, whatever?
We already removed the other stuff earlier, right?
Correct.
Yeah. Okay. Should we vote it out?
Motion.
Oh, we need a motion. Do I do it? No, I don't do it.
To send this red line out for public comment?
Okay. Second. Yeah.
Or is it a red line or clean version?
We send out both, so you're fine.
All right, I'll take the vote. Ali,
Yes.
Brown,
Yes.
Bradley, Coleman,
Yes.
Guzman, Mercado,
Yes.
Munoz, O'Reilly,
Yes.
Poindexter, Robbie,
Yes.
Riley.
Yes.
Shivers.
Yes.
Okay, so for the motion carried.
We've got an O'Reilly and a Riley.
Right, we did it.
So
Now, what about the time?
it's 12:28.
That was easy.
Oh, the amount to.
We were supposed to add that, right, to the proposal, but we didn't.
This was
You
just
asked
supposed
us
to be
to.
like 10 minutes or something, right?
Oh, you're talking about how many days for public comment?
Yeah,
Oh, yeah, we're
because
just
she
talking
had
about,
asked, and
how
we
many
had to
days
vote
for
that
public
out,
comment.
but we forgot to add it.
I mean, we're not doing 30 days, are we? Or can we do 30? But that still gets us past the Board of Trustees.
Yeah, it's a minimum of 30.
So let's just do 60 or 45.
So the earliest it would come back to the committee would be December 6th. Assuming there were no changes, it could go to the committee, to the Board of Trustees at their next meeting after December 6th. There's some uncertainty about, the board used to meet January, March, May, July, so forth, every 2 months about. The board is contemplating changing their schedule. So they will meet sometime right now between January and March is going to be their next meeting after the November meeting.
So, okay, so we can do 60 days and still, because their next meeting is January, what you're saying their next meeting is between January and March.
Yeah, so assuming,
Oh, we want it to come back to us in December.
We have to vote it to approve it.
Correct. And
Right,
so the
before we
meeting
send it.
after December is January 31st currently, maybe
Schedule.
changing based on people's schedules.
Let's do 30 days then, because that gets it back to us in December. And then we'll be able to, if they have an earlier meeting, then
It would
we'll
go to the
add that
January meeting. Correct.
Yeah.
But
Good.
how
So we
does
have to
that
vote
go-
that or just?
Yeah, how does that go with Erica? You're saying, the practice has been people don't have the opportunity to comment because of their own calendars.
The other ethics committees are really, like, they have their own committee meeting and then their, like, bar association has to approve it.
Right.
And you have to add a lot of time to build.
I mean, it's basically 90 day to get that input.
So
All of these lawyers who are on these committees can comment in their individual capacities if they.
Okay, so you think 30 days is appropriate? That's the question.
It's not appropriate for these ethics committees to get their.
You won't get, you will not get
They've already
feedback.
seen that, well, they
They've
haven't seen
seen
this.
This is
Well,
less,
except this one change.
Right, which is a major change.
I
so
And is there some reason we're trying to rush it? get to
Because
somebody.
good Lord, can we get something out? I mean,
Yeah, but that's not a good reason.
I know.
If we are honest in our saying we want comment, then let's take the time to get it, because there's nothing rushing us
I
except
know.
ourselves.
That's fine. I
And this
agree.
has been on for how many years?
4.
Yeah. So we're
All right, so
close. We're close. We're almost there.
Can we do it for 60 days and then it comes back to our February?
The next, yeah, it'd be probably the January meeting, or if that meeting's rescheduled. That should probably still work.
Yeah, it'll work.
The board schedule is a little.
So they're moving towards quarterly meetings.
Correct.
All right, let's just do 60 days then. Yeah.
Okay.
Do we think? Oh,
Do we need to vote on that or no?
okay.
All right.
So the other time question was it's 12:31.
I'm hungry.
have
Is there
lunch?
food?
We do have
Is it
lunch.
here?
Erica, before we break for lunch, can I just give the 2-second update on the lawyer's expert witness one?
Oh, yeah.
We just need more people in the working group for that to consider changes and then come back next time with proposed revisions.
This is the lawyer's expert witness.
Oh, okay.
So the current working group is
Dan.
Brandon and Dan.
Do you
So,
want to give Dan, if you can, do you want to give a quick high level overview of what that opinion discusses?
Yeah, it's basically a conflicts opinion for the most part, and we were revising scenario 3, which related to a lawyer and an expert at the same firm, and whether that was a conflict, and that was a source of discussion over multiple meetings. And then I did a revision of section 3, which changed the focus and the conclusion, but it hasn't been considered by the working group yet. And then we lost Sarah Bonola, who had been in charge of it. And maybe Joel was on that working group as well. So we need 1 or so more, maybe 2, to look at what I did and see what everybody thinks. It's either so amazing that nobody has any comments or nobody's read it yet.
wait. Does anybody have any questions? Any of the new members have any questions about? Okay. Should we ask for volunteers? So anybody would like to volunteer to be on the working group? I think we probably need, I don't know, 1 or 2. No volunteers here?
I can volunteer.
Okay, Carrie. It's a
You're
good,
at
yeah, it's a good one
Like-
to, yeah,
Steeped in litigation.
Yeah.
I'm sure I'll find it scintillating.
yes. But it's a good one to,
Get your
yeah,
feet
so
wet.
you're not, yeah, exactly.
Yeah.
Okay, we'll start with Carrie. Nobody on, okay. Okay. So that's done and we can break for lunch.
Do you want to, so it's 12:34, how we've gotten through
We,
one item.
I
Well,
know.
now 2.
I do, we have to get to the judges thing. The
Um,
thrill 3.6.
Is it, I mean, do you want to do a 30-minute lunch? Do you want to do an hour lunch?
No, let's do 30 minutes. I'd rather do 30 minutes.
Okay.
And I'm sure everybody on the 30 minutes, okay, guys on Zoom.
Okay, so that'd be 1:05.
Okay,
So we'll reconvene at 1:05.
cool.
All right, I'm pausing now.
Okay, let's get started then.
All right.
Okay, so I think we are moving on to item 4.4, which is the conversion clauses opinion 20-0005. And this is presented by Brandon.
Sure. I'll keep it really brief because we've talked about this a great deal. But for the new members, there's a 4.5-year history of an opinion addressing conversion clauses. Conversion clauses are defined, or perhaps will ultimately be more precisely defined, as terms in a contingent fee agreement that, if triggered, convert to an alternate fee, not a contingent fee. And several years back, there was an earlier draft of this opinion that said, you know, we have to scrutinize conversion clauses to make sure they don't impair the client's absolute right to switch attorneys, and to make sure that they aren't taking away a client's control of settlement decisions and litigation aims. And then also looking for unconscionability. And then that went out for public comment, came back, and then recently there was a draft of the opinion that shut the door entirely and said, no conversion clause is ethically permissible if it would exceed the quantum merit value of the lawyer services, which is already the default under the law in the absence of any such term. And that went out for public comment, got a bunch of public comment. And the question now is where to go with this opinion at all. I have a view that the prior draft of the opinion, the one that just set forth the factors to be considered in judging conversion clauses on a case-by-case basis to see if they are ethically permissible or would impair client rights, is actually still really useful. It would be great client protection. So, and just the genesis of this was in my practice, and some of the rest of us see a lot of contingent fee agreements where lawyers hold themselves out to potential clients as contingent fee attorneys. I don't get paid unless you get paid, blah, blah, blah. But these are tucked in the agreement. And these conversion clauses can give the attorneys a great deal of leverage over their clients to direct the outcome of litigations, and a great deal of perhaps inappropriate job security, because clients who don't have the money are afraid to fire attorneys and trigger a provision that they'd have to suddenly pay hourly fees. So I think and you know, a couple of years back when we had the earlier draft of the opinion, it had general support in the committee. So maybe something along those lines might have support in this committee, version of this committee, and be of utility in a public protection point of view. But we need some volunteers to work on the group. And actually, we got some in the last meeting, Erica. Do you remember that? And Topeka was interested in working on it and wasn't able to be at the last meeting. And new members who are interested in this should raise their hands until we hit our Bagley-Keene number. And then,
Which we're close to.
oh,
Yeah.
so maybe we
Yeah.
don't want any volunteers.
So just working group is currently Topeka, Eleanor, Elizabeth will be dropping off. So we have 3. So I guess we can do 2 more.
Okay, so if anyone's
Safely.
interested in that, and then the last comment I'll make was, everybody who gives us public comment on our opinions always makes fun of how long they are. And we tried to make this one much, much shorter by omitting the hypos. And then everyone was like, oh, we read these hypos.
Right.
So I don't know if they really want shorter opinions. You know, they-
Right, I know. Right. I mean, they write, some of them are very long public comment letters, you know,
Yes.
and they have a lot to
Saying
say.
your opinion.
Right,
There's like
exactly.
9 pages about why you need to do a short opinion.
Exactly. So, you know, they should understand how tough it is to get a point across in a short period, short length. So, okay, so do we want to get one more volunteer then, since
I
Elizabeth?
said 1 or 2, but who knows?
We've got, how many can we
There's
have?
currently 4. Elizabeth will no longer
We
be.
can have 5 on a working group.
So it's just, if it's a volunteer group,
You can have as many as you want.
you just can't be near a quorum.
Okay.
And so, but the challenge is the minute anyone wants to talk to anybody else about this, they can't. So that's fine, which, I mean, that's the recent practice is, it used to be more of a problem because people used to try and get solicit input in advance of
Right.
the meeting from different groups. It's not as much, and would provide feedback on drafts in advance of the meeting.
And then you're kind of violating the.
Correct.
Okay.
So it's not happening.
And then am I still the lead on this?
I believe Topeka is the current
Great.
lead.
Yeah.
Because I had
But she
my
wasn't
shot.
here at the last meeting when we talked about all the public comment and such, so, yeah.
That might be news to me. I wasn't aware of that.
Oh,
But
okay.
if someone is able to get me up to speed, I mean, I've seen the public comments that were submitted when we sent the last version out for review, but unfortunately wasn't able to make the last meeting, so might be a little bit behind.
I don't think you are. I think all we did
Yeah.
was talk about the public comment and say Topeka's not here. So I don't think much more got
Yeah,
done with
and
that.
it's really an issue. Like, I don't know if the committee's still interested in this opinion. I really liked it. I did what I could in a couple different iterations. And I did think, and I still think it has a public protection value, even in the non-absolutist form, you know, where we talk about the factors to be considered when evaluating conversion clauses.
Yeah.
But I don't know if everybody else feels that way. I hope there's still some interest in carrying it forward, but I'm not sure I should be lead on this anymore, considering what I accomplished. So.
But I will say, I think your knowledge of the opinion
Oh, yeah, I'll still be
is
involved.
very
Yes.
helpful and all the different permutations of it.
Just to be clear, the public comments here were from November 2022?
Well, there's 2 rounds of public comment, and I would actually think the more useful are the public comments to the first iteration of this opinion.
Yeah.
So anyone who wants to be involved in this, actually, there's a lot of background, unfortunately, sorry to say, but
From November 2022 is what is more valuable.
Yeah. I don't
moving
see the newer
forward.
ones in the SharePoint, so.
Okay.
Well, the newer ones were about whether or not it applies to transactional matters, right?
right.
Did they, I don't think anybody commented.
No,
Some,
no,
yeah, I thought people did. I
they
thought
did.
They don't like it, or they
Oh,
want
yeah.
us to be more careful if we think it should apply to transactional. That was not part of my genesis with this idea at all. It was really these,
The contingent.
contingent fee attorneys, sort of exercising more control over their clients than I think is appropriate under the rules of professional conduct.
Right.
So my suggestion will be that we kind of revert to that earlier draft and try to see if we can come up with something that the whole committee is comfortable with, that is of public protection value.
And say that it doesn't apply to transactional matters.
Yeah,
As long as Eleanor stays on the working group and
clarifies the definition.
Right.
and is going to be my representative on that viewpoint.
Stay on.
Okay, so we need a couple volunteers.
You don't. You have 3. You don't
Oh.
need a volunteer necessarily, so long as the 3 of you pointing at Topeka, and she probably can't see me pointing.
Might be
The
good to
screen.
get a new member on it.
You want some fresh ideas?
I think it might be a good idea.
So are there any volunteers? It's I don't know.
That sounds like
Is
a
there
We
no?
need a tie-breaking vote.
I don't know.
I did the
about-
last one.
Yeah, I think you and Topeka are maybe on the same page on this
Sorry.
currently, so you may already.
Have what you need.
Yeah, and if not, we meet again.
We're gonna come back.
And
We're gonna
yeah,
come
you
back.
I appreciate that.
It's okay. Yeah.
And based on what you say, you may get some new members.
Yeah, exactly. That's
Right?
typically what happens. If something
Right.
something that seems controversial, someone will volunteer to,
Feel strong.
which is why this opinion has taken.
How I ended up on
It's
it.
true.
That is how you ended up on it, I think.
Yeah, that is.
Yeah.
All right, we'll take it.
Okay. Thank you, Brandon.
Sure.
Okay. So let's move on to 4.5. That's the in-house counsel opinion. 2 opinions we're going to turn it into 2 opinions. And that's me. What we discussed at the last meeting is basically what we're discussing here, which is we are breaking the opinion up into 2 opinions. And so just some background on the in-house counsel opinion. What it covers, the first part is conflicts of interest between when a lawyer leaves one company, one in-house position, and goes to another in-house position, and how do the 1.9 conflicts, how that analysis applies to that particular situation. And then the second half is compensation for in-house lawyers, and when a lawyer has stock ownerships, the stock options, which is part of typically any sort of employment with a company, a large company. In-house counsel lawyers are also usually offered that type of compensation, but does that trigger a 1.8.1 disclosure conflict waiver requirement? We came to the opinion that it does not, but that is the controversial analysis. It does not in the typical in-house counsel employee-employer scenario. It does apply when, say, you are like a founder of a company along with other people. You're the legal counsel for a company that you're also founding. I forget the name of the case, but it's not a standard employment contract type relationship. So that opinion as one went out for public comment last springish time?
Yeah, fall, maybe even.
Oh, really?
Yeah, it's not. We haven't had it back that. Oh no, this is fall. Sorry. Yeah, spring, summer, yeah.
Yeah, and we
We
got,
might have back up.
yeah, so we got a lot of public comment feedback back on it. And one of the suggestions was that it was too long and it should be broken up into 2 opinions, which I agree with. And so we're going to take that approach. And then there were some other, very substantive comments about both aspects of the opinion. So we're kind of going back to the drawing board. And I'd like to have 2 working groups. One for the first opinion, the 1.9 conflict analysis part of the opinion. I don't know, at what point can we break it up? Like, we need to break it up into 2 opinions. Do they get 2 new numbers? You know what I mean?
Yeah, so it would be just a new opinion. So it would be essentially deleting what exists.
All my work.
Well, not deleting, moving,
Yeah.
copying and pasting over, to a new opinion number. So it would be a 24, I think that's just 0001. It's the first one we're
Okay.
deciding to do this year.
So I think that the first half, let's just deal with the 1.9 opinion for now, for this very moment. I think that that's the one that needs the most work. Because there's just a lot of, there's a lot of resources to draw from. And what I want to do is, one of the public comments from PREC, I think, was to address IP lawyers and how, the patent type conflicts come into play. And then non-IP lawyers, so there's just a lot of, there's a lot of law out there on those types of conflicts, and then we just need to apply it to the in-house context. So I know I've already talked to Emil about being on the working group for that. Does anybody else want to volunteer to be on that working group? And we've got, I'm sorry, the people on the working group now are me, Raquel, Brandon, and Dan, who's, I think, not here. And that's the working group for the whole. I mean, can we just start?
You could just start over with working group members. So essentially, the only concern is, depending on the number of people on each working group, if those 2 working groups think it's helpful to talk to each other, that's the challenge.
Okay, they probably won't, because they are really, there's no reason to talk about 1.9 in the 1.8.1. So we can just completely have 2 separate working groups, and you can be on both if you, right?
No.
Can I be on both?
No.
Oh, that's weird.
But because you'd be communicating.
But I gotta.
The liaison.
Yeah, you'd be creating.
I mean, 2 law firms.
Again, it depends on the volume, the size of these subcommittees.
Okay.
So if there's 3 and 3 and you're both, that's
okay.
fine.
Yeah.
But if it's bigger,
If there's 4 and 3, then.
Well, okay, let's see. Okay, let's get some volunteers for the 1.9. So we have Emil.
I was gonna.
wait, can you just,
I'm on the other one, right?
Yeah.
can you just clarify?
I don't want you on the other one.
Right. No, you have some space, because
I think, yeah,
I disagree.
I know.
And I'm of no use to you.
Yeah.
So,
Well,
So-
you should be on it.
I just, because what was in the SharePoint, it wasn't clear to me that it was separated.
it hasn't been separated
Okay,
yet.
so I'm not sure, so.
I separated it. I redlined it. For the last one, I think I just did the 1.9. So I deleted everything that had to do with 1.8.1, the second part, and what's in there now is just the 1.9.
Wait, I
It's
thought
about the stock option.
I think it's the
Oh.
it's the
Other way around. Oh,
just
sorry.
1.8.
Sorry.
So
Okay, so say what,
21-0001
Okay.
is about business transactions with clients. That's what 1.8.1 is.
Sorry,
which was the original scope we were talking about, more or less,
Well,
right?
more or less. We spent a lot of time in that space.
Okay.
I think.
Right.
Yeah.
And then
And then-
public comment introduced this other area more so for us
No.
to separate it out?
Yes.
Right, okay, all right, so, okay, I have that.
And then so the IP opinion will be the 1.9 opinion, which is duties to former clients.
Which currently exists.
Does not exist.
Does
It
not.
was.
It does.
It was. Yes. It was addressed
in this.
It's the whole first half of the opinion, but that one needs a lot of work.
Okay. So,
But
sorry.
it as a separate opinion topic does not exist, that's what
Yeah.
Right, that's the
confusion
difference.
is.
Okay,
Yeah.
so it's duties of what? IP?
To former.
Duties to former clients for in-house lawyers, basically.
Okay. Okay, so now what are you suggesting, Cassie?
I would like a working group for that new opinion. So I've got, and apparently well, we'll see if I'll be on it, but right now, then it's just Emil.
And that would be just
Great.
24-0001 would be the new opinion number for that opinion.
I mean, it's in my wheelhouse, but
Is it 24 or 25? Are we in fiscal year 25?
No, we're in 24.
When is it?
We don't go by fiscal.
I think, Carrie, I think it is in your wheelhouse.
yeah, I mean, I'm very comfortable with
Conflicts.
conflict analysis.
Yeah, and I think, I don't know, I think that you can, because, and you work, yeah, I think it'd be good. Why don't,
I don't know anything about.
I'll stay on this working group. I know.
If I clear out of the other working group, you can probably be on both.
Well, right, yeah. Yeah, but,
Is
okay,
that
so I'll be
helpful?
on this one with Emil and Carrie.
And you'll be the chair, the leader?
Yeah, who's
I'll be the lead.
Yeah, that's what I mean. Yeah.
Well,
So
I don't
Cassidy,
know.
just so that I'm clear, sorry, because I just back in, which is, you have two separate working groups for which one?
So right now, we're just dealing with the working group for the first part.
In-house counsel.
it-
In-house counsel.
It's
In-house
in-house counsel,
Right.
yeah,
Right, that's all
sorry,
she
in-house
wanted,
counsel,
right.
and it's
Yeah.
just on duties to former clients, the first half of that opinion that we're breaking out into a standalone opinion, and it'll be 24-0001. And we're gonna have Emil and Carrie and me as the, well, I think Emil, you should be the lead drafter, if you don't
I'll be
mind.
in that working group.
Okay, so Vakita.
Vakita will
is
be,
joining
okay.
that.
And then, because I did a terrible job as the lead drafter and I need to give it to
That's
somebody.
not true.
No, but it needs a different it needs to be reworked. And I'm,
So does lead drafter mean lead?
Yeah.
Okay, thank you.
and then the second opinion is, will it be 0002 or will it be the same?
No, it stays as 21-0003.
Okay, that's good. Okay, so 21-0003. Can I be on that? So it can't be on that one now that
Can,
Vicky is.
if we keep it small.
Okay,
And it's gonna get smaller because I'll back out, because you guys already have the benefit of my thoughts and I won't be helping.
I know.
Yeah.
Okay, and I'll be the lead drafter on that, and I just need one or two other.
So you have Raquel currently, unless she is no longer interested, and you have Dan currently, unless.
Okay, I mean, if anybody else, do you want to stay on it?
I do want to stay on it, but
I haven't done
would-
anything with you
Yeah,
guys.
right. So I would say for the committees, like if we're volunteering, to really have committee meetings.
I
So
know,
that has
I
been the
know.
downside, like
My
we're bringing
problem,
things forward, but we're not using the committee. And then we bring it here in the committee, then says things that could have been probably dismissed
can
at the
I,
committee level.
since you are very organized, can I ask you, I'll be the lead drafter and lead of the committee meetings. Can you schedule them and make me schedule them? Or can you do that?
Staff is very happy to schedule these working group meetings. I think I
Otherwise
volunteer
it's a
every meeting and every assignment agenda to do this.
Okay.
Um,
Can somebody just say you need to have a committee to back out from the next meeting? You need to have a committee meeting at least by this date or on this date or whatever. Like,
happy to.
yes, please, thank you.
Happy to.
Thank you.
And then
If you want to send a joint email to our group so everyone has everyone's email, that'd be great. We can figure it out.
yes, so we
Okay, so do we have enough people or?
I think we may have too many people. I'm going to confirm with OGC, and I will talk to you about whether or not you need to move off of one of these.
Okay.
Well, but
It would probably be that you're moving off of 24.
so Brandon, you're getting off. Is that what you said?
Yeah,
But then but I think I need to be on that. I mean, can I talk? Can I?
forgot.
I can't
Just
talk.
wondering.
Like if they have questions, because it's no. Okay. Well, I mean, I think Emil,
Oh, damn.
we'll talk, we'll figure it out. Okay.
So we will
because
have too many if she's on there? We shouldn't.
On both.
I mean, I trust
If she's on
Emil to
both, we
take the
will.
lead and not have to talk to me and figure it out.
Yeah,
As
way
long
too
as
much
you're,
faith in me.
well, right,
I mean,
we'll talk. I think
realistically, there's
wanna know
like
if he's comfortable with
one
that.
working group committee meeting between now and the December
I know.
6th meeting.
So
why
what does
don't-
that mean?
Yeah, we're not, I
You're
think
thinking
it's
of time.
quite ambitious to vote out both.
Okay.
To
At the same
have the goal
time.
of voting out both at the next one. So let's just have the committee, let's form our committees, have the committee meetings, and then we'll report back on status at the next meeting.
The full meeting.
The full
notice.
meeting, the full
Yes.
meeting, yes. So, and then you and I will talk as to whether or not I can be on both, but right now, it sounds like I can only be on one.
I think that's right.
Okay. And so no pressure, Mel, to like draft a full opinion ready to be voted
But go
out.
right ahead, don't.
And we will send you
The roster.
the new opinion, the 24001 excerpt of the prior opinion to the full working group, and we'll separate it on SharePoint and get it
Okay.
up. It's the new committee membership. It's prior committee membership wasn't as excited about SharePoint as you are today, which is great. So I think we gotta refresh it a little bit and get everything current.
That was very diplomatically stated.
Yeah. Frankly, there were a lot of
Glitches.
and IT access issues,
Right.
firewall issues
Right.
that have been very challenging. So we will get that current, and good to see it's being utilized.
Okay.
Very helpful.
Yeah, especially if it's got everything on it.
Yeah.
I think it doesn't right this moment.
Okay.
Okay, so I think that's that, right? We have everything is covered for that item. Okay, so now we're going to item 4.10. And this is, I think, yeah, we've talked about this the last meeting. We are looking to amend the rules of professional conduct, rules 3.6, 8.2, 8.4, potentially 4.1, to address, I guess, lawyer comments that threaten judges, judicial officers. And so just some background on this. Me, Topeka, who else? Who's Vakita is on it. Vakita, yeah.
And Brandon.
And
I
Brandon.
just didn't make the last meeting.
Yeah, you're not on here.
Oh, and Elizabeth. That's
Oh, yeah, and Elizabeth,
missing
right.
the list.
Which she could still be a part of it. Anyway, we've had a working group with a number of judges. And we just had a meeting. We've had a couple of meetings since our last COPRAC meeting to discuss these, proposed revisions, comments, an ethics opinion, something that that addresses public comments made by lawyers that tend to threaten the safety of judges. And so the last meeting we had, what did we talk about? Because I proposed the comments, we drafted the comments, and then we got Wendy's comments back, but we haven't had a meeting with the judges about
No.
that comment.
So there were two meetings with CJA since the last meeting. The first one, George Cardona, who's the chief trial counsel, so chief prosecutor, for the state bar, joined and discussed how these issues would be charged and brought currently.
Right.
Which led to the working group, and for the most part, the full working group, including CJA representatives and COPRAC representatives, to think that it would just be helpful to clarify in the comments to the rules that this type of conduct already is a violation of 8.4 primarily, as well as 8.2, which is traditionally, I think many of the people in the working group thought that was related more to judicial elections as opposed to any type of speak. And so that's kind of where the group was and continues to be either between that meeting and then the following meeting, there were a lot of case law was circulated. So this has been prosecuted in other jurisdictions more so than in California. However, California has two disciplinary cases that touch on this issue. There's the Marla Brown case, and then there's the why can I never
Pavone.
Yes, thank you. I can never remember that name. There's the Pavone case that touch on this too. So that was those opinions were circulated amongst the group. And for the most part, it was still thought that the comments would suffice. And then Cassidy drafted language that was circulated to the judge, to the working group that included CJA. Got some feedback, which is included in the agenda, like as discussion talking points, essentially for the committee to discuss. And then the thought being that if there are any changes to what was proposed that was circulated to CJA, that would go back for one more meeting with them as a broader working group. And then, I mean, or it could happen more, obviously, but that was the thought, is that we wouldn't vote necessarily on anything today to move forward.
So can we, yes, thank you for filling in what the history of it. So can we take a look at so the challenge here is that we are potentially proposing comments to a number of different rules that sort of cross-reference each other, but are designed to achieve the same thing, which is put in there that this, whatever particular rule covers, the type of speech that we're trying to regulate here without crossing the line into unconstitutional regulation. So is this where the comment? So for example, trial publicity is rule 3.6. A. So right now we have a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So this doesn't directly or expressly address, public comments that have a substantial likelihood of jeopardizing the safety of judges, for example. But you can see how it could fall within, having a substantial likelihood of a materially prejudicing adjudicative proceeding. Okay, so scroll down. Is this where we have my potential comment?
Yes, it's in blue.
Okay. Okay, so this is what I wrote. For purposes of this rule, extrajudicial statements may include statements concerning judicial officers and staff who preside over the matter. For purposes of this rule, means of public communication may include social media posts or other internet commentary, whether or not the lawyer makes such statements in their professional or personal capacity. And what did I say? I would think that this rule would still apply even if the lawyer used their private Twitter account.
Because I think it says means of public communication. So the question is
in their private capacity. Yeah.
No, but I think what you were trying to say here is if like your Twitter account is not public, does that mean it's not a public communication?
No, I think I was thinking that if you are, if you have a Twitter account and it's just you,
personally,
without saying that you're a lawyer or anything, because I think that was in the Mary Brown case, Marla Brown case. It was during the 2020.
Black Lives Matter.
Yeah, and she was posting on her personal Twitter account, not in connection with any proceeding or anything, but basically, I forget what the comments were, but it was like.
She was holding herself out as an attorney for LAPD.
Well, that was really awful. Yeah. So right. I mean, that was all, but she wasn't disciplined. It was all free speech. I mean, I know. Anyway, but there was a portion of the opinion that basically said that because she was using her private Twitter account and not representing herself as a lawyer, it was
fine.
Free speech. But
well, because I mean, generally speaking, we have First Amendment rights, and then like the issue with front load, right? It's in connection with their representation making statements, right? So you
Right.
can say false statements all day long, but in the scope of representation is when it becomes a problem.
Right, well, okay, so but here, I mean, you look at this rule, this doesn't necessarily, you can say a true fact or an opinion in this rule if it, and violate it if it materially prejudices the proceeding, right? I mean, the rule doesn't talk about false statements.
Sure.
So, but I don't know what, so, let's see. Okay, and then for extrajudicial statements disseminated by means of public communication that do not have a substantial likelihood of material. So this is where I'm kind of getting to that. If it doesn't, even if it doesn't have a substantial likelihood of a materially prejudicing the proceedings, may still be the basis if they're intentionally false, false statements, or statements of opinion that can be really reasonably understood as declaring or implying actual facts that are capable of being proven. So that's the either false or reckless disregard